Good morning. Good morning. Good morning. It is Thursday. No, it's Wednesday. Trial is a time construct. It's Wednesday. It's Wednesday. Wednesday, March 29th. We are in day 7 of the Gwyneth Paltrow ski collision trial. If you watched the end of the day yesterday after I finished streaming, they were talking about jury instructions. You might be wondering what a MUJI is. Utah model, not uniform, model Utah jury instructions, MUJI, MUJI. So they talked about the model Utah jury instructions yesterday, what instructions were in, what instructions were out. We saw that the plaintiff will be resting. The defense said they are not going to call Mr. Sanderson back to the stand for the rest of his cross-examination, allowing the plaintiff to rest. Both parties are now already on the record arguing their motions essentially to dismiss, motions for a finding that the jury could not find on the law that there is enough evidence for the jury to consider. So we're going back to a lesser preferred feed because they're the ones that start on time, even though the background noise is high. As we get into trial, we will switch feeds so we have a little bit better noise. So they're already on the record arguing to dismiss. So let's take a look at Owen's arguing this morning. Jury instructions are going to be finalized by the attorneys. Oh, I left my ring in my bathroom. Jury instructions are going to be finalized by the attorneys, and then we are going to see the jury come in. They're going to bring the jury and do more medical testimony today. Here's the bonus. Medical testimony means that Mr. Egan James is going to be doing the examination because he's the one doing the damages part of this trial. So let's roll right into court. But here's the upside. We get to do it at like 1.25 at least, so we can zoom. So there's that. Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it. Chat, let me know where you're coming in, what you're drinking. I've got hot water and I've got coffee this morning. Let's get going.
Please forgive my delay. I was taking a look at the filings from last night.
You're early as hell.
So
y'all said 8:45.
Let the record reflect that counsel are present. Are you ready to argue your directed verdict motion?
Yes, Your Honor.
Trial.
Okay, Mr. Owens.
I don't think I saw an opposition. So when was that?
They just
filed?
start
When did
early.
you have
At 7:03 this morning.
it? Very good.
Trials are dynamic. Trials move quickly, and there's a lot to keep on top of and not a lot of sleep. It is an intense experience. So I'm not surprised that he was like, it was filed at 7 o'clock this morning.
Plaintiff has rested their case. Is that accurate?
The parties are not present.
Yes, the plaintiff has rested their case.
The plaintiff
Accordingly,
is
it's appropriate
rested.
for me now to raise Rule 50 of the Utah Rules of Civil Procedure, which permits a party after
We know the rules. You're allowed to make this motion.
a party has been fully heard on an issue during a jury trial.
Yeah,
and
you
the
can make a
court
motion for directed verdict.
finds that a reasonable jury
Yeah.
would not have a legally sufficient evidentiary basis to find.
This is like Owens talking to the jury about going to ancient Greece. You're not arguing in front of the jury. The judge knows what the rules are. It's like that scene in Legally Blonde where the judge is like, I understand mens rea. What I don't understand is why you are giving me a lesson. And that's what it is. Why are you telling me what the rule is? The judge knows it's your time to make a motion for directed verdict. You don't need to explain. Just start making your motion. Like, stop it. Stop it, Owens.
Fine for the party on that issue. I address in particular, some of this argument predates us, but it's good to kind of bring us up to speed, I think. At one time, the plaintiff pursued both a negligence claim and a negligent infliction of emotional distress with punitive damages claim.
And that got yeeted on summary
Heard all
judgment.
arguments on that and granted Paltrow's motion on the
Right.
second claim, negligent infliction of emotional distress.
Right.
And punitive damages. At that time, the court made some findings. I have that ruling in front of me, dated August 2, 2021.
It's irrelevant to this argument. Ugh, this feed. Owens. This is just me being impatient. But these are long days.
The undisputed facts do not support the assertion that Ms. Paltrow committed a hit and run,
Owens knew this was coming.
among other findings.
No, he's not buffering.
When we
I'm
came
buffering.
to court 8 days ago, seems like 8 months ago, the court said, the plaintiff said, we're still asserting a negligence claim after the collision. I brought this to the court's attention, and Your Honor, we looked at the complaint, which only asserts negligence up to the ski collision. And you said, under general pleading standards, I'm going to hear evidence of it. We've
And
now
we're
heard
sped up.
evidence.
We're sped up.
I believe no one has
This is us
testified.
going fast.
And I know Your Honor asked us to marshal the evidence that would show it for the other side. So I have racked my brain on anyone saying that there was a breach of care, breach of a duty for Ms. Paltrow to not provide information and stick around longer. There has been some reference to the skier's responsibility code that has a sentence in there to that extent.
You brought that witness in.
Ms. Paltrow testified that she left only
He's still struggling with
after
her last name.
a
That's
designated
it's
Deer
just
Valley
funny to me at this
representative
point.
said,
As a
"You can go."
mispronouncer.
I think the undisputed testimony is that Mr. Erickson told Ramon,
I'm trying to also have a little empathy
I
for
guess he was in
Mr.
better
Owens because
mental
he
shape,
is sick.
who she was. Your buddy just took out Gwyneth Paltrow. And
Yeah,
we
he
know
does
that
look like he feels awful.
Mr.
He's sick.
Sanderson was aware of the name because by 9 p.m. he's texting
So I'm
that he's
trying
famous.
I'm trying to
And he's
have
famous
some
because
empathy
he
to
knew
Owen.
that he had collided
Owen's
with
trying.
Gwyneth Paltrow. So I don't see any
hang
evidence that, or any testimony from any expert or witness, fact witness, that there was a breach of that duty. Then moving to damages, one has to prove not just that there was a breach of a duty, but that it caused damages. I've heard zero testimony on that issue. And in fact, they did learn who it was. So a classic hit and run is someone just hurt me and left.
And that's
I don't know
already
who
been
that person is. It's a
removed.
phantom skier. That was never the case here.
Yeah, Owens is under the weather. He's been
Whitney
talking about it for
was
the
the
last few
toboggan
days. He put a
person from
mask
Deer
on
Valley.
when he started feeling ill.
She recalls hearing
He apologized to the
from
court and
Ramon.
the jury.
It was Gwyneth Paltrow. It was Gwyneth Paltrow. It was Gwyneth Paltrow.
So
So
Owens is sick.
I don't think the plaintiff has made
really
their case
trying.
on that, and I request directed verdict. On a somewhat broader issue,
So
the issue
I
of
have
negligence
some
generally,
empathy.
which would throw out the whole case.
I've been in court really rough.
The case law in Utah, as I read it, which I acknowledge may be overly optimistic, but that two skiers can collide without them, one of them being negligent. This has been the subject of one of my jury instructions. I don't believe I've heard anyone testify
I mean, true,
that they
he's not
saw Ms.
chewing gum.
Paltrow skiing negligently before the collision. The 3 or so skier on skier collision cases, as I read them, requires something more than because of the implied risks of skiing. Unlike, for instance, a car accident where someone has to be at fault. I think skiing is different when we strap on sticks on our feet and go down a slippery slope. The
I
implied
thought
risks,
that was going in different directions, but
including specifically collision with other skiers, they need something
it's
more.
the way he says buckle
I
up.
acknowledge the testimony of Mr. Bogger, who said if Gwyneth's story is accurate, there was a breach by Sanderson, excuse me, and he was asked the cross question, which was if Sanderson's story is correct, then Gwyneth breached the skier code. So I acknowledge that's out there. On its face, that sounds like, that's a classic jury question.
Y'all,
But I
this
think there's
chat
still
is
a dearth of testimony about
my
no
computer
one
and
saw
I
her
are
skiing
fighting.
negligently, certainly not recklessly or dangerously. I think the most they have is Carrie Oakes. We read part of that transcript of this idea that somehow at the top of the lift, Moses and/or Apple were saying, "Hey, Mom, we want you to watch us." That, I think, is the most. Now, it's funny, if you caught this from reading those kids' depositions, Moses says, "I don't remember saying that." Apple says, "I don't remember saying that." Gwyneth says, "I don't remember saying
And
that."
the skier said it
But
happened
Whitney-
earlier up on the
excuse me,
run.
Carrie Oakes said something to the effect that at some point they did. Now, I think there was a specific question, "Hey, was that just before the collision?" And I remember her testimony saying, "No." I mean, it was sort of this generic thing. It wasn't close in time. With that, I think it's appropriate to remove these issues from the jury. Thank you.
Thank you.
So this is a motion for directed verdict. They are trying to remove issues from the jury's consideration this morning after the plaintiff has rested. This is just like, you know, a
Judge.
motion to dismiss in criminal.
I assume you've read our brief that was filed early this morning.
The judge is
So
like,
I'd just
I'm
like to add
also
a few
tired.
points in addition to that.
It's a lot
Carrie's
of
own
work.
testimony supports the
doing this.
negligence claim against Gwyneth Paltrow. It's never changed. He said he heard a scream and then he was hit and he was out. This is corroborated many times by Craig Ramon, the only eyewitness who saw it a few seconds before the impact. He heard the scream and then turned over and saw Gwyneth Paltrow ski into the backside of Terry. It was a hard enough hit that it knocked him down and gave him 4 broken ribs and a concussion. That's very clear. That's causation and damages. Craig Ramon said that
Yeah, Owen's
Gwyneth
argument
Paltrow never
counts
talked with
against
anyone
Owen.
at the scene. There's, of course, disputed testimony that she swore at the time.
And this is why this has
at
to go
Terry
to the
at
jury.
scene. In either case, it shows negligence afterwards because it delayed the summoning of ski patrol.
Yeah,
Because
negligence after is really
Craig
an
Ramon said he was
odd
shocked or
stretch
stunned
for
that
me.
What's going on here? And then next thing you know, everyone leaves and he's there alone with Terry Sanderson.
So what's the evidence? As pointed out by the defendant in their briefing, what's
good
the evidence
argument
that
about the
delay
negligence after.
in treatment? And we get this in, you know, a medical malpractice case where there's an allegation that the diagnosis was delayed negligently, and there always has to be medical evidence
That there's
to support
an issue.
damages during that delay period.
Was there damage,
The delay, well,
additional
there was-
damage to
what were your
Terry
client's damages
Sanderson?
during, if it was delayed, what were your client's
At least
damages?
$1, Your Honor, worth of damages. He was frightened. There's evidence from Craig Ramon that he was frightened. Terry Sanderson testified he was frightened, and that added to his mental anguish.
He testified he was confused.
Compounding his mental health injuries.
But fright doesn't support a negligence claim, does it?
No, it does not.
It may just be worth $1 or more, but.
No, but
it
my
does-
question is,
it does support a negligence claim.
isn't that what negligent infliction of emotional
bing.
distress claim is all about? Whether
Yes.
fright can be recovered,
And
and that has already been evaluated
pleaded.
by the court?
It has been, but then we're focusing not on NIED, we're focusing on the delay in treatment, the delay in summoning the ski
Fright's
patrol.
not going to work for you.
And,
But the only damage that you can point to is fright.
there's
not
fright
sufficient.
and the delay and the fact
Let me
Stacey,
that
ask
I'm
you the
wearing
secondary
mine.
question I'd like you to comment on. Can she recover for that anyway, under the negligence claim?
can he or she?
Can't your client recover for
I
that?
thought the court said she.
That fright, or, you know, I assume under the jury instruction, that would be that would be mental anguish
Yes.
under the non-economic damages jury instruction. So can't you recover for that anyway? What does this give you, this post-accident conduct
Yes.
give you that you don't already have?
In comparison to the permanent brain injury, it's small, but it gives us additional damage that continues afterwards because
And why can't you argue that damage anyway?
we can, but it seems like the defense wants to cut off all evidence because of the motion for summary judgment
No.
on negligent infliction of emotional distress.
Well, yes.
But that only says that claim is gone, which has a different standard than normal negligence.
Correct.
But
So we're arguing that standard negligence
that claim's gone.
applies here. For
You don't
what
prove a
happened
claim
after
that
the
you're not
crashes.
proving.
We also have the violation of the skiers code and the Summit County ordinance, the safety.
Yeah,
which,
I'm more convinced by Owens this
requires
morning.
that the defendant stay on the scene to summon help, give out names. The evidence at trial shows
Terry,
that
ding, ding,
Terry
ding.
Sanderson
If you believe
was
Paltrow's
knocked out
side,
and didn't know what happened, and Whitney Smith did not believe Craig Ramon saying, "Hey, it was Gwyneth Paltrow," and so his what happened was he continued to be frightened even up until Whitney Smith took him down in the toboggan. And maybe at the
Marianne, this
ski,
judge is counting
first
time
aid
for
station,
arguments as well, because it takes
excuse
out
me,
of their day.
Miss
But he is
Whitney
starting
Smith,
earlier to
controller,
do it.
took care of Terry, and Craig Ramon had said it so many times, finally it dawned on Terry that no, it wasn't me, and he could relax because of that ongoing
For all of you coming in, I'll explain in a bit.
Delayed the treatment. Whitney Smith was not able to properly assess
Thank you,
Terry
Victor.
and properly investigate this, properly do the things that a patroller would normally do if Ms. Paltrow had hung around.
No jury present.
So the damage is, I think I'm not saying it's as big as the main
The
injury,
reason
which
he's
is the
making
brain
a hard
injury.
argument is because this
It's
is
not
a hard
the
argument to
broken
make
ribs
because
were
it doesn't
causing
fit the
pain.
law.
Terry was frightful about what had just happened to him. He's waking up from unconsciousness. There's clear testimony to all of that. Craig Ramon says that. Terry Sanderson says that. Craig Ramon confirms it. Even Whitney Smith confirms the disorientation. And even on the log of the ski patrol, it says disorientation.
My question still, though, is I agree with all of that. My question still is, though, if I grant a directed verdict as to liability on these allegations of post-accident
Kate, I interpret
failure
that
to
a
give
little
name and
differently.
address, failure to render aid, if I grant a directed verdict on those two things, why can't your client still recover for all of that
He
fright,
can.
for all of that delay? I mean, isn't that something that you can still argue under?
Oh, yes. We definitely agree with you on that, Your Honor.
So what does it get? What does it give you? I guess this post accident emissions.
I don't think it requires a special instruction. I think it's just the standard negligence. Just like, let's say there's a car crash, and the crash creates an injury. In addition, I'm sorry, I forgot to mention this. This was filed at 9:30 last night. Sam Goldstein testified right there that this delay and denial and
What day is this?
caused
Day
Terry
7?
to suffer additional psychological, as well as not neuropsychological, not brain damage, but psychological or psychiatric injury. Where to this day, where Terry is upset, more than upset.
I'm
but,
upset.
Sam Goldstein, the neuropsychologist, testified that this pattern has caused Terry to continue to suffer damages. It's not brain damage per se, but it's emotional or psychiatric or psychological trauma, not neuropsych. And Sam Goldstein, who's also a psychologist, testified to that, and that it's ongoing to this day on this witness stand right here. And
The
we don't want
party,
to
Terry
compare it to
Sanderson
the
is
brain
coming
injury,
to
but
court.
all combined, it's all those factors combined to support Terry's damage claim for negligence. And we just think that to artificially cut it off at the end of the impact, and when Ms. Paltrow bounces off Terry and slides
This
off
should
and Terry's
be
face down, as the
focusing
testimony of Craig
on
Ramon confirms,
The lawyer.
that's not the end of the story.
camera
The story
should be.
continues on and has affected Terry to this day, at least psychologically, and Sam Goldstein confirms that.
But that doesn't have anything to do with the
Let me get
period
this
after
straight
the
about,
collision.
So I understand the
The
failure
judge
to
is right.
render aid aspect. And are you relying on the ordinance for that?
Both the ordinance and the ski code, but it's not just the failure to render aid, it's also the, okay, go ahead.
And then the second question is failing to give name and address. How do you attach that to any damage?
Well, that's like in the car crash, and someone's dazed, concussion, and it may not be a hit and run. It may be something less. They stayed and they said, "Are you okay?" And if we assume they're correct, but they get up, and Craig Ramon says Gwyneth Paltrow didn't say anything. They just get up and then they drive away.
And Gwyneth said she had
Why, are you relying on the ordinance for the name and address thing too?
Both of them, but also just common sense. It could be a sidewalk.
what?
It could be a sidewalk, Your Honor.
Both of what? You're relying on both of them, you said? Both of
Both the
them?
ski ordinance and the skier's code.
Does the skier code say that you need to give your name and address?
No.
The skier's code, yes.
What's that exhibit, plaintiff's exhibit?
Well, it was testified to by Eric Christensen and I believe by Paul Bogger yesterday that there's a skier's code, and it's also testified to it's just kind of, it's standard, like,
Mr. Sorensen, do you have?
It's not just standard.
The plaintiff's exhibit for that skier code?
Let me look at it. I don't know right now. Just a second.
I can look for
Here it is, it's 37.
You're faster than I am.
Doesn't talk about giving your name and address. If that is possible evidence of negligence is the ordinance.
I think the ordinance, but also.
And the ordinance says that they're to give it to a Deer Valley employee, and she already
she had already
before
done
she
that.
even started that day.
Right.
The Deer Valley employee
Had
the
her name and her
ski
contact
instructors
info.
knew who she was and
Right,
had
but
her
the
contact
ski-
information.
But the clear testimony is the ski instructor Christensen did not give her information,
Then that's on
Doesn't require
Christensen.
the ordinance or the skiers code.
Either one.
The court is right. The plaintiff
Ordinance
is
says that
defending
they're to give it
against
to a Deer Valley employee if there's an accident. Am I reading that right?
motion.
I think that's Exhibit 38.
So we are on a directed verdict motion.
Yeah, at the very end of the Summit County reckless skiing ordinance, the last phrase. If it is necessary to secure aid for a person injured in the collision, the person securing such aid shall give his name and address as required herein after such aid is secured and before leaving the ski area.
Okay.
That's
And
38.
who's the person securing such aid?
Right.
I think that's the person that reported it, right? Wouldn't that be Mr. Ramon?
Yep.
It says any skier, above the first part of that full sentence of part C, skier's duty to notify operator or employee in event of collision. Any
There was an
skier
employee
involved in a
right there.
collision with another skier or person in which injury results shall give his name and address to an employee of the ski area operator or a member of the ski patrol.
And that's my
before
point.
leaving.
Didn't she do that? Isn't it undisputed that she gave that information to a ski
It wasn't-
area
it wasn't
area
on the-
operator?
It wasn't on the incident report. When my client sought that information, it wasn't listed on, in fact, it was whited out on the information he got, so he had no way to contact her, and he had to spend additional effort, psychological effort that was harmful to him, as per Dr. Goldstein. This continuous denial and obstruction added to his torment and damages. Now,
You could say it's wrong, it's small, but Dr. Goldstein said it was significant enough that he reported on it and said Terry
Gwyneth
Sanderson was
Paltrow
still
is on
suffering
the
from
phone
it
in the
5 years
room
later.
behind the
I understand the argument now.
safety glass.
Mr. Owens, any follow-up?
I think there's going to be some limiting here from the court on what they can do. Mr. Owens looks just
None of us
sick
wants to confuse the jury.
as hell.
They understand this is a negligence claim,
Paltrow, we can see you on the phone back there
but even I'm confused on this idea of she did something negligently after the
after
fact.
the collision.
There's been no evidence, no expert testimony or otherwise that the delay caused any harm whatsoever.
Testimony.
So Goldstein's testimony, as I recall, it was Eric Christensen's yelling, not Gwyneth Paltrow's not yelling. He described Mr. Sanderson observing
my
and
fault.
hearing a man screaming in his face, Eric Christensen. That's disputed by Mr. Christensen, but even if it's assuming it's to be true, that has nothing to do with Gwyneth Paltrow's personal information.
What about the argument that the difficulties encountered
trying to get my
later in
text
figuring
crew
out
sent
who this
out.
was and establishing, the correct information from the reporting caused additional, I guess, anguish on the part of Mr. Sanderson?
So Steve Graff, the Deer Valley head of operations, reported receiving 2 contacts from the patient.
Carolyn, the
Sorry,
judge has
from
already
Sanderson,
limited this
and that
a
he
lot.
responded and relayed.
So yes, the
Gwyneth's
law is on
proper
Paltrow's
information.
side
Realize
on
that's
this
your
argument.
evidence, that's the defendant's evidence, but what about the plaintiff's evidence? Could the jury not make some conclusions based on that are reasonable?
So, what
They're
do we
not
know
reasonable.
is by 6 hours he knew the person's name and actually thought it was cool. I'm famous, and I think the undisputed testimony is that the ski instructor told Ramon, "Your buddy just took out Gwyneth Paltrow." Now, if Sanderson's testimony is to believe, he wasn't in his best state to receive an address or anything. It was appropriate to talk to his friend. His friend Craig Ramon's right there. That was Gwyneth Paltrow. You can Google Gwyneth Paltrow and get an address for her work. They had that together. Then they were texting on their meetup group, like Gwyneth Paltrow did this.
They were messaging.
So they had information right away.
They knew who
the
it
mental
was.
distress and things, I think, as you said, they can talk about that, the aftermath, but not her actions. She didn't have negligent actions by, I think in all reports, Terry said, "I'm okay."
What about Terry's testimony and Mr. Goldstein? I guess that's what I'm focusing
Okay,
on, their
Gold-
evidence.
Goldstein's-
Terry says that he was frightened by the fact that he was just left there.
Yes.
And Dr. Goldstein substantiates that and substantiates that it was a continuing concern.
Goldstein, and I took it all to mean Christensen. Terry looked up, he saw a Deer Valley person in a green outfit, and he said, "Oh, good, there's someone here to help me." And then when the green Deer Valley guy skied away, which is contrary to Eric Christensen's testimony that he was the last on the scene, but let's presume Sanderson's testimony is correct. He felt abandoned. He didn't say, "I felt abandoned that Gwyneth left." I don't remember that testimony. So I think they're conflating the two. It's probably a good thing that Gwyneth didn't stay. She was pretty mad. She got the all clear from Christensen. He's okay. They observed no unconsciousness, by the way. He's on his feet. Ski patrol people, everything okay? Everything's okay? And then you can leave. The abandonment came from the ski employee. And that was for, keep in mind, a few minutes. Because a few minutes later, downhill, "I'm not okay." Okay, different story, but "I'm not okay. Let's flag the patroller." Whitney's there, and so we really are talking about a couple minutes. And it wasn't from the Gwyneth abandonment, it was from the ski patroller. He felt like the ski
we are
patroller
sped up
had
today.
bullied him and had abandoned him. He never said, I felt hurt and abandoned and frustrated that the skier, whose name they now knew, had left. That's all. Thank you.
All right. Thank you. Well, I don't want to delay the jury. Let me just rule
Yeah,
on these
Owens
motions.
is
So as to the
clearly
directed
sick.
motion on the negligence claim, the general negligence
This is a
claim
good
for the
motion
accident
for them.
itself, the court denies the motion for the reasons that, and the evidence that were marshaled
That was
by
going to
Mr.
happen.
Bueller. As to the post-accident conduct, it's a little more difficult, and it's also complicated by the fact that there was a negligent infliction of emotional distress claim that was dismissed, and essentially what the plaintiff is claiming is related to the post-accident conduct, is in the nature of
Negligent infliction.
of emotional distress or emotional or mental suffering, the fright associated with being left alone, and the fright associated with failure to give name and address. Let me just address that part first.
This is
so
the
I don't think there's any evidence that the jury could
post-accident
decide
behavior.
that Ms. Paltrow did not give her name and address to an employee of the ski area operator or a member of the ski patrol before leaving the vicinity. She did do that. So I don't believe that she violated her any duty that might be imposed by the ordinance, and that's the only place that there's any evidence that requires her to give her name and address at the scene of an accident. And so that post-conduct, I think, is out. As to the duty to render aid, I think that there is an issue of fact, and there is evidence that the jury could decide that the duty to render aid was not followed. And I'm relying on the plaintiff's testimony himself, as well as that of Sam Goldstein and Mr. Ramon. I think that I acknowledge that the testimony on this issue was primarily directed at the Deer Valley employee and the fact that they allegedly abandoned the plaintiff at the scene. But I think that there's enough testimony from both the plaintiff, Mr. Ramon, and then also from Sam Goldstein to also include the defendant herself.
Casey Cat, that's for the
And I'm not
jury
commenting at
to
all on
determine.
any of the evidence
So
that the
that's
defendants
for
have presented
argument.
on that issue. I'm only focused on what the plaintiff presented, because I'm required to do that.
Yes.
I'm also required to grant them any reasonable inferences
Yes,
from that evidence
because
that the
it's
jury
the
might be able to
non-moving
make.
party.
So-
You
so
grant
that
every
portion of
inference
the,
in the direction of the non-moving
motion
party.
is denied. I guess what that will leave for us is to determine how to read that ordinance.
jury will get to
in terms of
consider
the jury
it.
instruction. So we still have that to resolve after we spoke last night. Any questions or clarifications?
No, Your Honor.
Okay, why don't we
So-
just take a short break then, and we'll return with the jury.
All
Thank you.
right.
Are there any
I'm-
other preliminary issues?
Oh,
Okay.
geez. I'm going to get us caught up real quick. As the court goes on break, I'm going to switch feeds because this sound is always overgained for my ears and their preference. So I'm going to make sure that we are caught up to the jury coming in into court, Gwyneth Paltrow coming into court, and I will explain real quick what just happened. So I beg the indulgence of the chat, and then we can watch court a little bit on 1.25. So I beg the chat's indulgence. Hi, chat. They were doing a motion for directed verdict. This is going to limit what can be argued on closing. What the court decided is that there is enough evidence for the jury to consider whether or not there was a breach of a duty of care after the collision that would have required Gwyneth Paltrow to do something more. The judge considered all of the plaintiff's evidence and said there's a question here, and the question can be considered by the jury, but kept out the exchanging of information bit. So it's making sure that they are not arguing, well, there can be negligence in all these different ways. There's negligence in a limited amount of ways. So with that, we are going to go back into court this morning. Let me make sure the volume's up. I'm going to put this at 1.25 speed and then speed it up from there if needed, because we are a bit delayed because court started early this morning and I do not. But we've got time. We'll catch up on one of the court breaks. So let's go to court as we're getting ready to bring the jury. Gwyneth Paltrow is coming into court. And let me turn this up just a little bit more. That seems about right. All right. Good morning, chat. Let's go. Let's continue on. So with all of that, what hoodie am I wearing? I am wearing the purple. I have questions. It is new to the shop this week. So I am there. The jury is present. Required particular said Law and Crime did an interview with the sleuth who gave the lawyers the meetup post. He found more, including that Terry Sanderson went skiing again relatively soon after the accident. Need to bring him back. That is
morning.
for the lawyers to discover.
We're just waiting on a few more parties, so it'll just be a moment.
Love the purple hoodie. Thank you. So the court is waiting for, I don't know who. Let's see. Required particular, Spidey discovered that the duty to give info wasn't a duty at the time of the accident. It's a newer rule. The attorneys are obligated to address that, but they didn't. But the judge is keeping some of that out anyway. Breaking View said, I don't understand,
There's
Emily.
no snow this morning, but I understand we may get some later, so.
You mean the judge is saying no more evidence? No. The plaintiff has
So let the record
rested.
reflect that all parties and counsel are present, the jury is present. And I realize we took a few witnesses out of order.
The plaintiff has finished
but
testifying.
At this point, does the plaintiff rest its case?
Yes, Your Honor.
Okay. Are you ready
So-
to call your next witness?
Yes, Your Honor. We called Dr. Carl Black, our neuroradiology expert.
Thank you.
Dr. Carl Black, neuroradiology. I appreciate when
Mr.
Owen
Black, right up
says
here.
it, so at least we know what we're doing.
Dr. Black?
Do you swear that the testimony you are about to give at the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good morning. Come have a seat.
Good morning, Annika.
Once you get
Fantastic.
situated, if you could state your full name and spell it.
The judge dismissed some of the theories, but not any. The claim
My name is
is
Carl Milton Black.
negligence.
C-A-R-L.
So only some theories
M-I-L-T-O-N,
were yeeted.
B-L-A-C-K.
Thanks for being here with us, Dr. Black. Let's begin by just asking you what your role is in this case.
I was asked to review imaging related to this case between the years of 2009
Can
through
y'all hear well?
2021.
And what expertise do you have that allows you to opine on imaging of brain scans?
I'm a fellowship-trained neuroradiologist. I also have fellowship training in vascular and interventional radiology, and I'm double board certified by the American Board of Radiology in
He's not just board
neuroradiology and
certified.
vascular and interventional
He's
radiology.
double board
Is
certified.
there anything about that experience and training
Take that,
is
Bainbridge
relevant
scholars.
to your opinions in this case?
Yes, I have expertise in analyzing imaging of the brain.
Okay. And let's just
Double.
go over very quickly the images that you reviewed. What maybe give us the type of image and then the years that those images were taken.
The imaging
CT,
consisted
they're
mainly
doing
of
both.
CT,
They're doing both.
Doppler, and MRI. The range of years dated back to imaging performed at the Veterans Administration Hospital in 2009, and then subsequently imaging again at the Veterans Administration in 2016, imaging performed at COG-FX in 2017, and subsequent imaging performed in 2021 at Blue Rock Medical or Riverwoods.
And does that mean that you reviewed imaging both before the ski accident and after the ski accident?
Yes.
And in your review of the imaging, did you see any evidence of traumatic brain injury after the accident?
No.
Did you see any evidence in the imaging before the accident that might be consistent with
Interesting.
Mr. Sanderson's post-accident symptoms?
Yes.
And we'll talk about the specifics of those. Are you also familiar with Dr. Gibby's opinions in this case? As the jury will recall, Dr. Wendell Gibby is plaintiff's radiology expert. Are you aware of that?
I have reviewed the reports that were provided by Dr. Gibby on imaging that he performed in 2021. I've also reviewed his deposition that he provided to the court.
And so you're familiar with his opinions in this case?
As reflected in his reports and his deposition, yes.
Yeah. In addition to the imaging itself, did you read the reports that were created by the radiologists who took that imaging?
Yes.
And we'll look at those reports in detail. I just want to make it clear that what you've reviewed, you feel like you've reviewed everything you needed to assess
Yes,
this imaging
James, that's what he
that
said.
you've described.
Yes, I've reviewed both the imaging itself and the reports associated with each of those studies.
Okay, so I want to start with an exhibit the plaintiff or the jury has already seen. It's a exhibit to Dr. Gibby's deposition. I believe you've seen this. I'll show it, and for reference, I know we marked it as one of plaintiff's exhibits, and I'm forgetting the number now. I just had it in my head. Do you guys recall?
Which one?
This one right here. We added it to the end. I apologize. I had it in my mind, and now I forgot.
The lawyers just phone a friend. It's so funny. They
Well,
just ask.
While they're looking that up, Dr. Black, have you seen this image before?
I have.
And what is it?
This is a axial image from an MRI performed
Thanks,
at Cognitive
Chad.
FX on October 18th, 2017. Specifically, it's a FLAIR T2 sequence.
And do you understand
Closed captions are
CogFX or
frozen.
Cognitive FX to be Dr. Fong's clinic?
That's my understanding.
Okay, just to help the jury, they have heard from Dr. Fong. So an MRI was taken at Dr. Fong's clinic. Were those green arrows
don't know
part of the
why.
MRI initially?
No,
What-
those
what-
were, I believe, placed by Dr. Gibby during his deposition.
I don't know
Okay.
what's
And
going on with the
what
closed
do you
captioning.
understand those to mean? What did Dr. Gibby put those arrows there for?
Those arrows are pointing to what he's terming white matter disease.
And what is white matter disease?
White matter disease reflects scarring in the brain, and often it occurs around the ventricles that you see here. In the deposition, Dr. Gibby's using these arrows to point to areas where he suspected that these may relate to trauma.
I see. And I'm noting that Peter Jensen on my team just noted that this is Plaintiff Exhibit 31, I believe, to the record.
Okay.
Okay, so those same points that we're looking at with the green arrows, in your understanding of Dr. Gibby's opinions, is he pointing to those as evidence of post-collision problems for Mr. Sanderson?
That's what he indicates in his deposition, yes.
But in your review of the prior imaging, do those same findings show up?
If you review the imaging from 2009, at which time Mr. Sanderson had a comprehensive imaging workup that included imaging of his brain as well as the blood vessels that supply his brain, these findings were present in 2009.
I see. And I believe you've prepared some images that you've taken from the prior to the accident images and post-accident images and noted those. And is that correct?
That's correct.
And we'll show those to the jury in just a second. But what I want to do while we have this one up is give you a pointer and have you point to other findings that you see.
Parts of the
in this,
brain, parts of the brain.
MRI from 2017. Is
Brains.
that okay? Will that help you explain to the jury your opinions about this image?
Yeah, I'm happy to do that.
Okay. I'll bring it to you. May I approach, Your Honor? Okay,
That's
Dr.
not what I
Black,
meant.
So
That's
we've talked
what I
about
meant.
the green arrows. What other findings do you see here?
So one finding that was consistent over...
Can't hear it.
Yeah, should we get him a microphone? Sorry, Dr. Black.
The handheld's right there.
Get him a handheld.
Thank you.
So if you're just coming in, hi, welcome. Go ahead and do the YouTube things. This is a
study does show
neurologist.
imaging that was...
They're going through imaging of the plaintiff's brain.
A decade of imaging in this case, dating back to 2009.
Owens is wearing a
One of them
mask
was,
because he is
a
under
mild
the
degree
weather.
of cortical volume loss or loss of brain volume. The other was in this area here, these are the ventricles, and it showed as disproportionate enlargement of the ventricles relative to the amount of
So this is what
tissue
was going
loss
on for
in
the
gray matter
defendant
and overall brain volume.
plaintiff
The
before
findings
this accident.
around the ventricles, these white areas, are very typical of what's called microvascular disease, where brain matter around the ventricles is deprived of oxygen over a long period of time, and that results in gliosis or scarring. This pattern is very typical of what we call microvascular ischemic white matter disease, and that was present in 2009.
Microvascular
And did I hear you
ischemic
correctly
white matter
earlier?
disease.
Do you have specialized training in those particular findings beyond what a typical radiologist might have?
My fellowship training and experience in neuroradiology and consistently reading brain MRI gives me expertise in looking at these findings, which we often see on a regular basis.
I see. So this is a post-ski collision image, correct?
This particular sequence is from 2019.
Right.
My understanding is the accident occurred in 2016.
Yeah, and I think you said 19, but you pointed to
Yes,
2017.
I'm sorry, 2017. Yes,
Right.
correct.
Yes, and so you said earlier, I believe, that the same findings you're pointing to, again, not just Dr. Gibby's findings with the green arrows, but the other ones you just talked about, they're in the pre-accident images. Is that right?
Yes, my review of the imaging that was done at the Veterans Administration Hospital in 2009 shows these similar findings, and in the reports that were provided by the neuroradiologists who read the imaging at that time, they described these findings.
Right. Okay. So let's maybe have you sit down again, and I'll pull up
He likes
those
the handheld.
slides that you made. Thank you.
All of the teachers like the handheld. They like to be able to walk around and be like, this is this and that is that. They enjoy the moment. The plaintiff is in court this morning. We have seen the attorneys argued. We know James is dealing with damages, so he's going to be
So
dealing
this
with all
is
of these
Defendant's
doctors.
Exhibit 101A
We heard
through,
yesterday he normally does medical malpractice types
believe
of
it's A through
cases, so
F.
that's not a surprise
And,
that he's familiar
Your
with
Honor, I
doctors.
move to admit this as a demonstrative exhibit.
No objection.
Defense Exhibit 101A through F is received for demonstrative purposes.
Thank you, Your Honor. So, Dr. Black, do you recognize this slide?
Yes, this slide is also what's called a flare sequence, a T2 flare sequence, done in what's called an axial plane, which just means the orientation, the way the image was acquired through the brain. This image was acquired in March of 2009 at the Veterans Administration Hospital.
So that's before the accident, correct?
Yes,
Yeah, and again, when I say accident, I mean the ski collision in 2016.
yes.
And it's not terribly easy to see, but I can call it out here. There's a little arrow. Do you recognize that?
I put that arrow there, yes.
Okay, and what does it point to?
That arrow points to white matter disease, similar to what Dr. Gibby had pointed out in the imaging from 2017.
Right. Okay. So, in other words, this is a prior finding that's the same as the post-accident finding Dr. Gibby saw.
Yes, about 8 years earlier.
Okay, got it. And
That's
what is this
very,
finding associated
very
with?
interesting.
Again, most commonly we see this with what we term microvascular ischemic white matter
Same
disease.
as what Dr. Gibby saw,
There are
but 8 years
predisposing
before the accident.
risk factors for this, where in some patients it may be accelerated, but it's typically a process that's due to pathology or abnormalities in the very small, some of the smallest blood vessels that supply the brain, particularly around the ventricles.
And I'll
Interesting.
go to the next one, which is 101B, and again, call out a section here at the bottom. There's kind of a faint red arrow. Again,
Right,
did you put
that's
that there?
That's
And
big
why'd you put that
testimony.
there?
It goes by fast, but there are
Because
these
it
big
again
moments
shows the same pattern of
that
white matter
matter.
disease that was demonstrated on MRI of
And his
2017.
James's
Okay, so
question
again,
making it clear.
a finding before the
helps.
accident that was there also after the accident.
That's correct.
And
Let
what's
me
this
make these
finding
small.
associated with?
The exact same description.
Got it. Okay, then
That's
if we move
big,
to
big testimony for me.
101C,
I'm
there's yet
interested to
another
see what
red
Cross
arrow. I
does with
take it you
this.
put that there.
Yes.
And is it again to point out that Dr. Gibby's finding of post-accident problems in that area preceded the accident?
Yes,
It's
accounting
funny how
for
these big
technical
moments in
differences,
court
the way
don't always feel
in the
like big
plane
moments,
of the way
right?
this exam was acquired from 2009 to 2017.
They-
These findings are identical.
Right.
They
got it.
collect the puzzle
Okay,
pieces
and
to put
they're
together in
also associated
closing.
with the same things you've described already.
Most likely microvascular disease, and that's when he underwent his comprehensive imaging workup at the VA hospital in 2009. It was also attributed to vascular disease
No,
at that time.
I have it on
Okay.
1.5.
So, number
I have it
Defense Exhibit
sped up.
101D is like your same version of that 2017 image that Dr. Gibby looked at.
Correct.
And it has those same spots. So I'll just use the laser here. Again, these arrows are kind of faint on my copy. I apologize, but they're pointing to those same points we've just looked at previously. Is that right?
Yes.
Okay. And then if we go to the next image, this is a new image we haven't looked at, correct?
Correct.
And this one's from 2021.
No, Nightbox.
As it's marked. Where was this image taken? Do you
They're
recall?
arguing
Yes,
that
this image
most of the
was
injury was caused
obtained
before
at,
was the ball was
Blue Rock
already
Medical
rolling
over
down the
Woods
hill
Imaging,
before the accident.
which Dr. Gibby owns, and this is the same sequence that we've shown before as far as how it is technically obtained by MRI. same slice.
Got it. And again, we have some arrows, correct?
Correct.
And those
The
are your
accident
arrows.
was 2015.
And they're showing, I take it, the same disease process or same findings that you've seen in the 2009 and then 2017 images.
That's correct.
So you're seeing this same condition in the brain for many years, both before the accident and after it.
Over an 11-year period. a
James
similar
is
pattern of
asking
white matter
good
disease, yes.
questions, making it
And then if we
clear.
go to the next image, 101F, we call out that upper left quadrant arrow. And again,
And I've got this
I
sped
believe,
up, and
you
James
put
is
that
making
there,
it very
correct?
clear.
And kind of for the same reasons to show these conditions
And I've got it sped
persist
up 'cause we're
from
a bit behind
2009
live
before the
court.
accident to this image in 2021.
Oh,
That's correct.
2016, that's right.
Okay, thank you. And let's see. So let's.
I'm giving the jury 101G. That was referenced, was it not?
That would be the next one, which
James
I
was
haven't
like-
referenced. But if there's no objection, that's just the
I
next
was
bit of the slides.
Getting
objection.
there,
What is that?
Owens.
Can you move that?
Owens is rushing James ahead. James was like, that's the next one. I was getting there.
Is that 101F?
So this is 101F
I
on the
appreciate
screen, and then
James
what
standing
Steve has
his
put here
ground.
is 101G.
These are their evidence before and
Defense
afters.
Exhibit 101G, is that also for demonstrative purposes?
Yes, Your Honor.
Okay. Received for
thanks,
demonstrative
Melissa D.
purposes?
Okay,
We are
so
the internet's favorite place to watch a trial.
Dr. Black, you've used various medical terminology that we might not all be familiar with, microvascular disease, for example.
I think we feel familiar
Can you
now.
give us a sense of what, in lay person's terms, what these sorts of findings are correlated with, how they impact a person?
Sure. The microvascular disease itself is a term that's used to describe micro just meaning very small, and then vascular, the blood vessels. That when these blood vessels over time become diseased, which happens in a broad section of the population, in some people it's accelerated due to underlying high blood pressure or perhaps other diseases of the blood vessels, then you start to see scarring initially around the ventricles. These are unlike large strokes that may affect the cortex of the brain. These are smaller areas where the blood vessels are compromised, and it results in scarring of the tissue around the ventricles, and that's why we call it white matter disease. The
the
other
time
imaging
is
in
a huge
2009
factor
from
here
the Veterans
today.
Administration, the CT angio specifically looked at the larger blood vessels that supplied Mr. Sanderson's brain, and in those images they found plaque or hardening of the arteries in the carotid bifurcation on his right side, and then also in the larger blood vessels inside of his brain near where his retinal arteries come off, or the cavernous carotid arteries.
So
And
I've
those
got
also
this
show
sped up a
plaque
little
or
bit. That's why it
atherosclerosis.
feels
Okay,
fast.
is it too reductive to say that these findings are an indication
Trish,
of an
thank you for
aging
sharing
brain?
this.
Well, aging can result in this because we're all deteriorating to some degree or other.
I
every
love
day
that
we
the
live.
chat has
Right.
become
But because we have a baseline,
has become
you can
the James Egan musical
attribute
fan
certain
club.
findings. If it's happening at an accelerated level, given someone's age, then it might indicate there's underlying medical problems. The other finding that was present that was consistently present was the enlargement of the ventricles, which on all images seemed to be disproportionate or out of the proportion to the amount of atrophy of the brain.
Owens, you're not a good
Several,
trial assistant.
in
Just sit
several
down, it's fine.
reports, there was a suggestion of a diagnosis of normal pressure hydrocephalus. And in fact, if you go to the image, let's see, that
There may be
maybe the
one
2000
rebuttal witness,
There's a, well,
and it'll
2021,
be
we don't have it on here.
the
There was
doctor with
an
the green
image
screen.
that shows what's called transependymal edema. And that's fluid that leaks through the side of the ventricle due to pressure buildup in the ventricle. And that's a supporting finding
I'm ready to
from
move
an
on
imaging
from water to
perspective
coffee,
on
but I'm
normal
trying to
pressure
finish
hydrocephalus.
hydrating.
Obviously, that has to be correlated to someone's clinical presentation and symptoms, and that's where a neurologist would play an important role in that.
I see. And just I think the jury has heard about this term multiple times, but let's spend just a moment from your perspective defining what normal pressure
I
hydrocephalus is.
haven't listened yet. I will.
Normal pressure hydrocephalus is basically an imbalance of the way fluid's managed within the ventricular system of the brain, and it can result in confusion or unsteadiness of gait when it's clinically applicable. But from an imaging perspective, that diagnosis is suggested when the ventricles seem to be disproportionately enlarged relative to the brain volume itself.
So from an imaging perspective, there was strong indication that Mr. Sanderson had normal pressure hydrocephalus.
It
Oh,
was suggested
let me do this at a break.
in
I'll talk about this real quick.
every brain study he's had since 2009.
And is it a progressive condition? In other words, does it get worse with time?
Yes, it can.
And then I'm going to go to another image that, or another report, a document that the jury has already
Thanks,
seen.
Tina.
This one we looked at with Dr. Gibby. This is his report from March 3rd, 2021. Do you remember seeing this?
Yes, I reviewed this.
Okay. I believe it's also part of Gibby's packet in Plaintiff's Exhibit 31. What I want to point out, I think I called this out with Dr. Gibby. I want you to comment on it. There's a
They
part
are
of this report
closing
that says, I
tomorrow
don't see any
morning.
sign
They
of shearing
only
injury.
have
Do
today.
you see that?
I see his report, yes.
And do you
Only
agree with
for
that?
Tonight.
I agree with this report, yes.
Okay, and
It sounds like they're racing
what
because
do
I
you
have them
understand
sped up.
Dr. Gibby's opinions to be as shearing injury is
I
concerned?
do have them sped
So
up.
this report was performed
Which is delightful.
on March 3rd, 2021.
I'm gonna start all trials an hour
specifically
late
looking
so I can
for
just speed it
evidence
up.
of brain trauma. So that was the clinical history provided to Dr. Gibby, and he was looking in detail for any imaging findings that would support closed head injury.
And would shearing injury be one of those?
Yeah, the things that Dr. Gibby would have been looking for, or that any of us would look for when we're
These are the
evaluating,
experts rebutting the
study in a
plaintiff's
patient with
experts.
Brain injury would be shearing of the white matter tracts. These are very delicate tracts where if there's a rapid deceleration of the brain, those can shear. When they do shear, they deposit little microhemorrhages that leave blood products in the brain, specifically iron that's found in hemoglobin. So in another sequence, Dr. Gibby would have been looking for any evidence of iron deposition, which he mentions here, pathologic iron deposition. And then the other thing you would look for is bruising of the cortex of the brain. The brain does move to some degree with inside
Sanderson
the skull
was in the
because of
courtroom
it's
the last
bathed in
time they
cerebrospinal
scanned
fluid.
over that way.
So if there's a rapid deceleration, the brain cortex can hit up against the skull and cause a bruise. In some cases, it can result in hemorrhage, but in other cases, it can result in focal atrophy at those locations. So in this case, none of the imaging showed a contusion, no shear injury, and no evidence of pathologic hemorrhage in the brain.
What would you expect to see in a person's imaging after some kind of traumatic brain injury?
Well, it depends on the severity, of course.
Right.
In mild trauma, nothing.
Okay. And how would you describe Dr. Gibby's opinions about the evidence of trauma in his Mr. Sanderson's post-collision imaging?
In Dr. Gibby's report, where he specifically was looking for evidence of trauma, he emphatically states there is no evidence of post-traumatic brain injury in his report. Now, it is interesting because it contradicts to some degree his description in his deposition.
And how does it contradict that?
Well,
So the report and the depo
Dr. Gibby mentions
disagree.
that in his
Interesting.
deposition that the white matter disease that we've reviewed is very typical of shear injury or pathologic brain injury. But yet in his own report of the imaging which was performed at his center, which is identical to the findings in 2017 where he was offering that opinion in his deposition, he emphatically states that there is no evidence of post-traumatic brain injury.
Objection.
Angie,
State from
no.
Testimony.
Overruled, the jury will have to recall the testimony.
Criminal trials
Or
are
Dr.
not
Black, do you
kept on a
see on this
schedule
report
like
any
this.
indication that this image was compared to prior images?
No,
Is that common to do when you do a report, you compare it to prior images?
there were 3 imaging studies done after the accident. One was a CT scan done again at the Veterans Administration in 2016, which was compared to 2009. The imaging that was performed in 2017 and 2021 make no reference of comparison dating back to 2009. So I presume those images were not available to them.
Is that a problem? Does that lead to any limitations of a study if you don't look back at the prior studies?
It does limit the way that a neuroradiologist can interpret an image. If you have prior imaging, it helps put things into context and can narrow the differential or the possibilities in terms of a diagnosis. For example, in this case, knowing that the white matter disease pre-existed in 2009
this witness is easy to
helpful
follow.
to exclude
James's
that
questioning
it's
is
a
easy to
result of
follow.
shear injury from an accident in 2016.
This is-
So yes,
this is the
comparison
battle of
imaging,
the
when
experts
it's
part of this
available,
trial.
is
It's just-
of extreme importance.
So are you critical of Dr. Gibby for not doing that comparison?
Not necessarily critical. Those images just may not have been available to him. I think if you offer an opinion as to causality and you do have imaging that's available from the Veterans Administration and someone draws a conclusion without baseline imaging taken into account,
Yeah, having
that
baseline
can
imaging
alter
is
someone's
great.
conclusion and lead to an error.
Not everybody's
in
going to have
how
it, but if you
they're,
have it, you need to look.
discussing why that abnormality exists.
And do you believe that sort of
That's
error
fair.
occurred here with Dr. Gibby's opinion?
I do. I think he was limited by the unavailability or lack of comparison to the imaging that was done in 2009. Yes.
Mackenzie.
Okay, I want to move to another report.
Making
This
me
is for
pick
that
favorite
2017 image we
children.
started with, the one with the green arrows that was
I
taken
like
at
both
Dr.
James
Fong's
and
clinic.
Barber.
It's in Plaintiff's Exhibit 33, page 8. I don't know that we've shown it, so
Barber's a
I
little
moved to admit it.
snarkier. And I do love some snark. I don't
It's
think James
Plaintiff's
has a
Exhibit
snarky bone in his
33,
body.
page 8, and I guess 8 and 9. There's 2 pages.
It feels like that if
Just a
James and I
report.
sat down to have a drink, he would A, probably not drink, and B, be offended every time I said
Exhibit
fuck.
33, Fong's packet, pages.
But I like him as a lawyer.
All of us are,
Oh, we
we're already
admitted.
admitted.
Okay, great.
But I'd
I
rather
just know
hang
we
out
didn't
with
admit
Barber.
some. Yep.
Is 33 received?
That was
33 was not received.
Was 33 received or not? All right, y'all figure it out amongst it. Talks amongst yourselves. So this morning, chat, the first thing that we had going on was the motion for directed verdict, limiting the theories of
May I publish
negligence.
it to the jury, Your Honor?
This is the
No objection.
expert.
Plaintiff's Exhibit
We have
33,
one
page
day
8
of
is
witnesses
received.
left.
James, do you want it from start
This
to
is
end?
it.
Or was there just one?
No, just 2 pages.
And they do
page
need to
8
run through
and
these
page 9.
witnesses.
Page
I
8
also
and
have
page
it
9
sped
are
up.
received.
Yeah, this is, again, the report connected to the image that we looked at first, taken at Dr. Fong's clinic in 2017. Is that correct, Dr. Black?
But
That's
James,
correct.
James does
And
sing.
I want to point to, I guess we should first ask the question we were just asking about Dr. Gibby. Do you see any
I'm trying to
comparison
zoom
here?
in and I can't.
No.
This is so hard
Okay, so
to
the
see.
same
This is from
points you made
Cognitive
about the
Affects
limitations
report.
of Dr. Gibby's report you would say about this report. Is that right?
Correct.
And if we call out this bottom part that's called impressions, I'd like for you to comment on whether you agree with these.
I do agree with these impressions.
And will you take us through them in layperson's terminology? Maybe we could start. We've covered some parts of the ventricles. You feel like you've explained that?
Well, I think we can, let me just emphasize one other
Sure,
aspect of
go ahead.
of the ventricles. Also, I think it's important to note that the context of this study being acquired was specifically with the intent to look for any evidence of closed head injury or significant brain trauma. And so there are pertinent negatives that are pointed out by the radiologist who interpreted this exam that did not exist, like hemorrhage in the brain or evidence of,
Yes,
of a
Peter does not
contusion.
appear to
So
be
there are
chewing gum in
pertinent
court
negatives,
today.
even with
The
a strong
lawyers on the
bias
internet had a
looking for those
strong reaction.
because of the history.
So
The-
just to make sure I'm
yeah.
understanding you, that when you talk about bias, you're just saying going into this image, they heard a history of traumatic brain injury, concussion, so they're
Confirmation bias is what they're
apprised
talking
of the
about.
possibility of various findings that might be associated with that, and they want to find them, or they're looking for
Correct.
them.
That's correct.
Foundation.
Sustained for leading.
So
I love that James just kind of
maybe
goes.
just comment on bias again, because that term is used in various ways. What do
When
you
I-
mean when you talk about bias in these?
When I'm referring to bias,
question.
I'm talking professionally. When we interpret an exam, the clinical context of that exam or why that exam is being obtained is important to us. If somebody has an infection or somebody has a brain tumor, then we understand that and we're looking for various findings that would support that. In this case, if somebody has known trauma, then that would alert the radiologist to look for certain findings. So in the case of the MRI performed in 2017 and the one performed in 2021, there would be an alert to look for findings related to trauma. So the negatives, the pertinent negatives in the exam from 2007 and 2021 would rule out imaging evidence of significant head trauma.
Yeah. So in other words, they're looking for trauma, but they did not find it. Is
Yes.
that right? Okay, so let's go to these findings again. Here in number 2, there's normal pressure hydrocephalus.
Looking
We've
at
talked about
something
that. But there are a
is
couple other
different
things.
when you know
Um,
the background.
Normal aging brain,
than
Alzheimer's,
not having a
dementia,
background, looking and seeing what you
subcortical
see.
arteriosclerotic encephalopathy, multi-infarct dementia. Did I read all that correctly?
You did.
And those are some big words. Can you comment on those to help the jury understand what these are doing in this report?
Well, some of these are clinical descriptors, which would require a neurologist to make a correlation by examining that patient, because imaging can show a lot of things that don't necessarily
I forget
manifest
what he
in someone
does.
clinically. So it's important to always take it into clinical context. The one
Aren't you a
description here that
neurologist?
actually reflects underlying pathology would be the arteriosclerotic encephalopathy. That's just a big word for diseases of the blood vessels, specifically plaque or hardening of the arteries.
There's a lot
The
of
comprehensive
words.
workup that was done at the Veterans Administration in 2009 did show evidence of vascular disease at that time in the carotid arteries in the neck and also in the brain. And at that time, the white matter disease, which again was present over a decade later, was attributed to vascular disease.
Did you see any evidence in the imaging that correlates with vision problems?
No. There was mention of it with the functional
that's right, the
MRI,
neuroradiology.
but that is beyond my expertise.
Okay. You'd
My
leave that to a
brain has
neurologist
stopped,
to speak
like-
to, or somebody else.
Somebody has who expertise in functional imaging.
Okay.
Functional aging. My brain stopped 2 days ago.
Okay, so we can take this down,
Morgan,
I think.
congratulations. Congratulations on matching.
Did you note anything in the?
I hope you got to have
let
a
me
fun
ask
party.
First, are you aware that Dr. Gibby actually met with Mr. Sanderson?
I'm aware of that.
And is there anything about that meeting that has any bearing on your opinions today?
The only bearing it would have is that Dr. Gibby makes mention in his report that he had told Mr. Sanderson that it's possible
said
you
they
could go through
haven't
all of
talked
this
about why.
workup and not find any
They
evidence of
didn't. They
post-traumatic
didn't
brain
talk
injury.
about the complaint that led him to get the
And
imaging.
why would that be significant to you?
Simply
Uh,
because the
I wonder if it was
obviously
the stroke
intent
event
of
with his
that workup was
eye.
to specifically look for evidence of brain injury.
It might have been the stroke event with his eye.
I believe the jury's heard Dr. Gibby give an opinion that I want to see if you remember and what your comment might be, your response to it might be. If the images prior to the accident
I'll be interested to see the cross on this.
are similar to the post-accident imaging,
Yeah, I think.
in other words, if
No,
the
I think
imaging
2009
prior
was
showed
the
things
eye,
that were
the stroke
post-accident,
event with the eye.
would that mean that you cannot say the prior findings were caused by the accident?
Objection leading Ms. State's prior testimony.
The jury will have to
As to
determine the
leading
testimony.
sustained?
Okay, so do you recall Dr. Gibby giving an opinion that if the pre-accident findings the post-accident findings are found in the pre-accident imaging, that you could not say that
The accident caused
post-accident
them.
imaging was caused by the accident?
Objection leading.
Sustained?
Okay.
You were
What do you
very close
recall
on that one,
Dr. Gibby
James.
saying about the relationship between the pre-accident imaging and the post-accident imaging?
Yes,
My
break it
opinion
down.
on that would be based on his deposition. If you'd like, I can read 2 areas of his deposition that I think answer your question.
Sure, go ahead.
So,
Objection hearsay.
Sustained?
Okay, so let's just ask
He's
you this question.
allowed to
Do you have
rely
any
on it.
opinions about
Yes.
whether the post-accident imaging findings can be attributed to, from an imaging perspective, the collision, the ski collision?
Objection leading.
Overruled?
we ask that again.
Yes. Do you have any
Did we
opinions
catch up?
about whether the
We're caught up.
post-accident imaging findings can be attributed to the collision?
Yes.
What is that opinion?
That those findings predate the accident and date back to at least 2009.
That's
as confirmed
clear.
by a comprehensive imaging workup of Mr. Sanderson's brain performed at the Veterans Administration Hospital.
Great, are we done? What else do you have to ask?
Um,
James, what else do you need to ask?
And so do you believe those post-accident, I apologize that I keep messing this up. You believe that those post-accident imaging findings are in any way related to the collision?
No.
That's
And what was the reason for that 2009 workup, to your knowledge?
Thanks, James. The chat wanted to know.
Unfortunately, Mr. Sanderson had suffered a retinal artery occlusion, a central retinal artery occlusion
The eye.
that resulted in blindness in one eye. And so he was undergoing a workup for risk factors that would relate to that.
Okay.
Chat, we
And,
figured it out, and they
um,
asked it. Ask and you shall receive today. We're just putting it out there.
Do you know any of the people that have done any of his imaging?
I'm familiar with him, yes.
Yeah, and so that 2009 workup, or do you know the people that did that workup?
Yes.
And do you trust the findings that they came to?
Yeah. They're very experienced and well-trained, yes.
Okay, great. That's all the questions I have for now.
Good job, James.
Thank you.
I'm
you,
looking
Mr.
forward to
Egan.
this.
Mr. Bueller?
I'm going to start at the end. You're not an eye doctor, are you?
I'm not.
And you said the imaging from the retinal artery occlusion means blindness in the eye. Does that mean total blindness? Or?
That's beyond my expertise, and I'm not familiar enough with his clinical condition to comment on that.
So your term blindness is probably a little broad.
Broad. I only gained that from the histories that were provided with his imaging studies.
Okay, so.
And he was asked about that.
he
Why?
may
What
still
was this
have,
related
some
to?
vision in his eye, even though.
It's
Absolutely.
like, sir, I'm not an optometrist.
So I just wanted
I'm a
to point that
radiologist,
out.
not an ophthalmologist. Damn it. I feel like the camera is just focused on the microphone here in front of the witness and not the witness, and it's just slightly blurred, and it just today is destroying my spirit. But I was cranky yesterday, so I'm not surprised that that's also making me cranky.
Let's see. Is it true you were a partner of Dr. Wendell Gibby's?
Yes.
Oh,
And how long ago was
that's
that?
interesting.
It's been probably over 10 years.
Okay.
Did y'all get along?
And
I want to know the tea.
so you know his work, correct?
Correct.
And you're not critical of his work in general, are you?
No, not at all.
Okay. You never conducted an exam of the client, Terry Sanderson.
No.
You understand there was a sudden change after the ski crash in Terry Sanderson's condition, brain health.
From my review of the records, that's my understanding.
You understand that
And he
through...
did a record review.
You read before and after witnesses who confirmed there was a sudden change after the collision, correct?
Would you mind asking that again?
Did you read before and after witness testimony?
He's not sure what you mean by before and after
You-
witness, I think
you
is the
didn't-
problem.
So you didn't read... Isn't before and after witness testimony important to understanding someone's brain injury?
I think it's very important, but it was beyond the scope of what I was to do.
He did a record
concentrated
review.
only on his imaging.
Okay, so you didn't have the before and after information that would improve the diagnosis that you might, or the opinions
Right.
you might give today in court to this jury.
I understood that with respect to the imaging, we were looking for evidence of brain trauma as would manifest on imaging, and so that's where I concentrated my focus.
Well,
And I think that's fair.
You said that MTBI may not be shown on an MRI, true?
A mild brain injury?
Yes,
Correct.
okay.
I like when the
So,
lawyer's trying to
Dr.
use
Sanderson
legal
could have a
terms,
brain injury.
and then
mild
the doctor
traumatic
is
brain
like,
injury may
I'm
not be
double
shown up on
board
imaging,
certified,
right?
so.
That's correct.
Okay.
It's kind of funny to me.
Now, the 2009 imaging, it was asymptomatic, true?
Again, I don't understand. I'm not the clinician who examined him at
Treated.
that time, and I can only look at his imaging in the context of the information, so I don't feel qualified to answer your question.
Thank you.
Did you guys subscribe yet? Well, there's pauses in questioning now that we're not at
So,
1.25.
From the imaging from 2009,
Will you do the
2017,
YouTube things? Thanks.
2021.
Appreciate it.
There's no change, right?
Very little change.
Okay. Dr. Black, no one's given a diagnosis that Terry Sanderson has clinical NPH or normal pressure
Normal Neil Patrick Harris.
hydrocephalus, true?
I don't know that for sure.
Okay.
BS. Those are your initials.
the,
I'm not calling BS.
NPH was not clinically
That's what cross-examination is largely.
diagnosed by his
You want
VA
the jury to
doctors,
focus on the
as far
lawyer's
as you know,
questions.
correct?
As far as I know, it was only suggested, well, it was suggested in most of his imaging
He's looking at
studies.
the jury.
But I don't know what clinical correlation was made.
Okay, and so clinical correlation means that there was some specialist at the VA or elsewhere that understood his NPH was showing symptoms, correct?
That's correct.
Okay.
So Bueller is doing his cross.
So you don't
He's
need
now explaining it to the jury
pathological
with yes/no
evidence
questions.
of, to have a MTBI, correct?
When you say pathological, are you saying imaging evidence?
Okay.
Yes.
Y'all,
That's correct.
it's driving me crazy. I am unbalanced because I left my ring in the bathroom. I have to go get it. I realize this might be a neurodivergence thing, but it is making me absolutely crazy. I'll be right back.
So, Dr. Black, imaging can show a lot that that hasn't really manifested or shown up, correct?
Will you state that one more time?
Okay, imaging can show a lot of things that hasn't shown up in a clinical setting. No,
Yes, correct.
so Terry could have these problems that show up on imaging, but there's no symptoms that would affect him from, or stop him from skiing, for instance.
It's possible, yes.
Okay. And in general, you would prefer to have an actual exam of the patient to render your opinions true?
I think that imaging correlated with a clinical exam is the correct way to assess a patient's condition.
So you would prefer to have an exam, correct?
Yes. Well,
Okay.
prefer, I mean, I think they correlate.
Okay.
The information's valuable in both circumstances, but optimally in decision making, you want both types of information.
And so your opinions are not as strong as they would be without this exam, right?
Without a clinical exam,
Yeah.
Woo.
there's my opinions are certainly limited to his imaging.
Thank you.
You bet.
Perfect timing.
Thank you, Mr. Bueller.
How was Cross?
Mr. Egan?
Dr. Black, you were asked about before and after witnesses, the family members, people close to Mr. Sanderson.
Do you need to do this much?
Before and after the accident.
I'm not sure I understood that question, but
Okay, well,
You
my,
can-
my question is just whether opinions from such
Did I feel
witnesses
balanced now?
would affect your read of the objective findings in the images.
no, they would not.
And what about if you actually met with Mr. Sanderson, would that change the objective findings in the images?
No, because I would defer to a neurologist or neuropsychologist, someone who with that kind of expertise to evaluate Mr. Sanderson. My area of expertise is in brain imaging.
I look
Do
at the
you typically
images.
evaluate patients when you read their imaging?
With regard to brain imaging, no.
No, engineers
after,
don't talk to customers. I talk to customers, so the engineers don't have to talk
Let's
to the
see,
customers.
I guess we did show one of these boards, but you didn't get to see it. I want to make sure you see it so the jury knows that you've seen
Okay.
it. And I'll show you. This is 101G, and these are the same. Are these the same images we were looking at on the screen?
Yes.
And they show that before there was a finding that was also after the collision. Is that right?
Correct.
Okay, so I think the jury's already seen that. And then we also
I feel like he's
have
like, I look at the images.
two more boards which we didn't show. Your Honor, I move to admit 101H and 101I for demonstrative purposes.
James
Objection.
can just be done.
Defense Exhibit 101H and 101I, or is this
James, you
plaintiff's
just can be
exhibits?
done.
These are ours, yes.
Defense exhibits are received for demonstrative
Yes,
purposes?
check out the big brains
I'll
on
show you
Brad.
first, Dr. Black. Is this the same idea as the board we just saw?
Yes.
Okay, just with different findings.
Yes.
Okay. and
I
then-
like Bueller's demeanor as
That
well.
was 101H, and this is-
Objection beyond the scope.
Overruled?
and then this is 101I. And it's the
Yes.
same idea.
Yes.
Okay, so I just showed the jury 101H, 101I.
They're like, we want you to have our big boards. I like big
And then the last
boards.
question for you, Dr. Black, is whether after questioning from Mr. Bueller, Have your opinions about these objective findings you've been discussing on the imaging changed?
They have not.
Okay, thank you.
So earlier you said you preferred to have objective findings from a neurologist or neuropsychologist, correct?
For clinical correlation, absolutely.
Yeah, for clinical correlation. Would you defer to someone like Dr. Goldstein?
I mean, I don't know him, so that name doesn't mean anything
He
to
said
me.
someone like him.
He's a neuropsychologist who testified in this trial. You didn't know that?
No.
So Dr. Goldstein provided clinical correlation, and that would help your opinions if you had that, true?
Sure.
Okay.
Somebody has expertise clinically that I don't have, but it doesn't change how I interpret the images or my view of these findings.
The images
So
are the
your
images.
opinions are limited to your view of the images and not the clinical findings, true?
Correct.
Thank you.
You bet.
Mr. Egan,
That's all you're.
you may be excused. Thank you.
Valkyrie, I know it's spelled Bueller not like the movie. I just can't get it out of my brain like the movie. All right.
Witness, or take a brief break.
No, witness.
Is this witness going to take a bit?
Robert Host. Hesh, sorry. And I would think, I could be on and off in a half hour, I think.
You lie.
Okay. Why don't we go ahead and take a break because there will be cross-examination, I'm sure. We'll take a recess now.
He's like, I can be on and off in a half an hour. I don't believe you, sir. I like big boards and I cannot lie. You other brothers can't deny. When an exhibit walks in, I don't know, on a firm, but I've lost it now. Y'all can absolutely help. Rewrite the rest of the lyrics about the exhibities. They're taking a quick break so we can catch up on questions. The judge just walked off. He was like, good God. I know earlier it felt like we were speeding through this because we were. I had it at 1.25 to try to catch up because we got a little bit behind. They started earlier than I had anticipated doing their motions this morning. I thought they were starting at 8:45 with motions, local court time. They started a bit earlier than that. So with all of it, let's get to questions. Where we're at here at the end of the day yesterday, let's swoop a doop. We're going to just recenter. At the end of the day yesterday, I had a band parent meeting. So we had very important band parent things that had to be done. And they went over the jury instructions. You might now be familiar with the term MUJI. And you're like, what is a MUJI? Model Utah Jury Instructions. MUJI is what they call their jury instructions. So they were talking about, would there be special instructions? Would they stick to the MUJI, stick to the guidelines? Every jurisdiction has model jury instructions, and then you can modify them. So if you need to modify the jury instructions, you can write things in, cross things out, decide what's coming in and out. That's what they were doing at the end of the day yesterday. The court went over how much time they had left. At the end of the day, the plaintiff had 15 hours, 19 minutes. The defense had 14 hours, 50 minutes. That includes closing argument. So with all of that, they have to get through the day today, and then they have closing arguments tomorrow morning. The judge very much wants this jury to get this case at lunch tomorrow. He's like, give it to them at lunch. I don't know if the judge thinks they're coming back after lunch tomorrow, but I think this judge wants to be done with this trial by Friday. Like, get it to them, be done. And I think we might have a verdict by Friday. I don't know if we'll have a verdict Thursday, but I think we might have a verdict by Friday. So I think this judge is moving. They might start a little earlier tomorrow as well to get in the jury instructions. I will always cover the jury instructions if I'm able to, like tomorrow, because I very much want to hear exactly the law that the jury is going to have to apply here the standards, because we're going to be dealing with like a clear and convincing standard. The standards on this civil trial are going to be much different than a criminal trial like you may be used to. The jury doesn't have to be unanimous, 3/4. The standard is not beyond a reasonable doubt. It's going to be clear and convincing for this. They've got to decide if there was a duty, if it was breached, and then damages. How they determine damages is going to be interesting, because they've heard about the change in life and they're arguing really non-economic damages, pain, suffering. It's why you haven't seen medical bills. He hasn't paid them. They are arguing for the trauma and payment for those non-economic damages. So with all of it, I think that catches us up to where we are. Let's get to questions real quick while the court is on this break and go from there. So, Data said, I hear Muji and I think lovely, addictive Japanese stationery and classically simple clothing. Same. Same. I am a giant nerd when it comes to all things notebooks, pens, planners. This, I realize, may be an ADHD trait, but it is also stickers, the all of it. The all of it. If you think that my nerdiness is limited to one category of nerd, it is multiple categories of nerd. Stacy, question, why were there no medical records brought into this case? There were medical records brought in the forms of the expert reports, and the expert reports rely on the underlying medical records. So the expert reports were brought in, but we didn't see like medical billing brought in because that isn't a part of this case. Question, I saw talk on social media about the GoPro footage being found, submitted. What's up with that? Is it true? I have not seen anything to indicate that's true. What was found by the internet, and it still shocks me that the lawyers couldn't find it. I am still shocked that the lawyers couldn't type in the meetup link and go find it, or create a meetup account and go find it. Still stunned that the lawyers couldn't figure this out. This case has been going on since 2016. Stunned that their level of inquiry and inquisitiveness ended with, the link won't click. Or at least that's what it seems like to me. Like, I tried to click the link and I can't click the link. The amount of attorneys I worked with that would have difficulty with email, would not be able to open things. Technology and lawyers sometimes are like oil and water. They just don't mix well, which means if you are technologically advanced and interested in the field of law, there will be lots of people who want to hire you, because it is a growing and technological world, and lawyers, especially the senior guard, most of them are habitually bad with tech. But no, I don't think the GoPro footage has been found. I don't think GoPro footage exists. I think that is probably referring to the link in the meetup group that led to pictures. Susan said, even if he was frightened and delayed care, that's not Gwyneth Paltrow's fault. Medical staff showed up. It was not up to her to keep them there. They did show up, and then we heard him tell them they were fine, Flamingo, this was from earlier this morning. I don't get what they were arguing about. They were making a motion to limit the theories of negligence this morning. I ordered my I Have Questions hoodie last night. It cost 100 AUD because of exchange rates, but I can't wait. I didn't know exchange rates were that hard. Let me go look and see if there's anything I can do in the shop about exchange rates. Miguelina, will you help me make a note to look into exchange rates and see if there's anything we can do? I don't know if there's anything we can do, but I will look, because that is a lot, and that is never the goal. Like totally said, bring the Gwyneth. Question, does it mean anything that the judge is questioning him and not Owens? The judge was questioning the party that is opposing the motion more, but also this motion leaned into the law better. My brain stopped on that one, but the law supported the defense's argument on those motions for some things. So JB said that Terry Sanderson, my brain has to flip that around, is a sad man. I feel for his family having to deal with this. I don't believe his lawyers or his testimony one bit. I believe that there was a ski collision. I believe his ribs were broken. I believe things changed for him afterwards. I honestly believe things changed for him afterwards. I don't know if it's because of this collision or if it exasperated his existing struggles. I think that he got fixated on this accident. I believe that's true. I don't know what Gwyneth Paltrow caused, but it makes me sad. I'm sad. I feel empathy for him. I just don't think Gwyneth Paltrow caused all of it. And that's why they're trying to limit the damages. This jury could very easily come back 50-50. And if they come back 50-50, no one gets anything, no one gets legal fees, and everybody walks away. Exasperated. No, Ranch said Freudian slip, Emily. I can't pronounce exasperated well at all. I can't. And I struggle with pronunciation. As I'm an adult, I find out that my neurospiciness knows no bounds. And there are things that I didn't even know were a struggle or had a name that are struggles. Elizabeth said, thank you for all you do for us law nerds. You are welcome. Siren said, disabled vet here. Thank you for your service. The VA gives referrals for what they don't offer. I doubt he spent anything on medical at all. 3 whatever million is for his ego. 3 whatever million is for his feelings. The pain, the suffering, the after effects of this. Kim asking the real question. Did they finish cross-examination of the plaintiff? No, they didn't. And yesterday they said they weren't going to. They're just letting it go because they need to get into the rest of their witnesses. Jules Smith says, so they're working on the jury instructions language, right? That's what they were doing last night. They were. And again, I have the plaintiff at 15 hours, has used 15 hours or 15 hours, 19 minutes, and the defense has used 14 hours, 50 minutes. So of their 20 hours that they each had for a 40-hour trial. Emily, did you know James Egan, the Paltrow lawyer, has a Spotify and sings great? I know that he has music on Spotify and iTunes. I have not had a chance to listen yet. I am still trying to catch up on Vanderpump Rules. And honestly, after streaming trial days, I just need quiet time. I also tend to work quite late getting things done. Tonight is a night I actually won't be working quite late because the podcast will be out today and everything else. So tonight will be a night I will just go to bed early. Thank you for your time and expertise. You are welcome. I am here. Has Dr. B ever testified as an expert? He has done depositions and record reviews, but he has not testified in trial. Why? Because a lot of things settle. Hi from Wales, UK. Love your channel. Here since Step V Heard, waiting for ADHD diagnosis. Both kids neurodiverse too. I live here now. Well, you are in a good community for that. EDB, love the purple sweatshirt. You look fabulous. And can you say what size yours is? Think you've said you like them bigger. I do. This one is an XL. These are the sweatshirts. The hoodies are unisex sizing. We are also looking for a distributor that has a wider size range in this color sweatshirt. They were hard to find. This one is an XL, but I have also worn them in 2XL and in large. The large is a more fitted, like, I don't know, dressier sweatshirt. And then as I get them bigger, they are a little more comfortable. I do like my hoodies a little roomy, especially around the girls. So they can run a little long in the waist. I'm a little short waisted, so they do have space, but they are cut to be unisex, and they also have a sizing guide on the Law Nerd Shop. So if you're interested in that, all of those are over at Law Nerd Shop. Question, plaintiff rested, is cross the only way they have to counter this? Data for insights. This was a fantastic question, and I knew I wanted to give a little bit of a longer answer to it. Yes, but they also have some opportunity for rebuttal. So we will see that a little bit later. Jackie, Emily, me and my planner, babes, friends, love watching you while planning and journaling. You are the best. I am such a nerd for planning and journaling. I had tickets for Go Wild before it got shut down for the Panini. One of these years I will get there. Right now I am using like 4 because I love them. I could talk about planners forever. I will move on. Some of my original YouTube videos were about planners and how I was using my planner for ADHD and what have you. So right now I'm in my notebook right now. Is there anything secret on this? Is Happy Planner disc bounds. We're in a disc bound vibe right now. Question, why are they kept to such a strict schedule to the point that they're rushing through to closing tomorrow and then each side limited to 1 hour? Because if you don't, If you don't, as the court, they will go on and on and on and on. Can you, the courts, first of all, get backed up for sure. So they're like, look, this is a negligence case where two people hit each other on a ski slope. You have 40 hours. You each get 20. That's all you need. Otherwise, could you imagine a jury listening to another week of experts arguing? You could argue forever. You could pick down every little sentence. This makes the lawyers get to the point, and it keeps them concise for the jury. There isn't any more needed in this case. They have to plan their time. They have to get to the most important evidence. They also get to determine that with the judge and give estimates to the judge. Once they give their estimates, they have to stick to it. And they know all of this. In a civil trial, they know this. They've done the depositions. They've done all of it. They know what these witnesses are going to say and when. Oh, one of my feeds shows court back and the other one doesn't. So I'm gonna back up on this new witness real quick because I was chatting. I started talking about planners and then I lost my mind. So Owens is back questioning this next witness. I had them back up. One of my feeds just doesn't show court being back. I don't know how it got so behind. So, all right, let me, oh, it'll take us 3 minutes to catch up though. Let me get the court feed back up. I actually don't mind getting to do court at like 1.25. It's actually quite pleasant. It's actually quite nice. All right, court is back. As I was answering questions, let's put the volume on.
Do you swear that the testimony you are about to give in the case now
We are
before
at
the court will be the truth,
1.25.
the whole truth, and nothing but the truth, so help you God? Thank you.
Good morning. If you could start by stating your full name and spell it out for us.
My name is
Uh-oh.
Robert Hesch, R-O-B-E-R-T.
Ben Chu might be one of my
H-O-E-S-C-H.
favorite attorneys of all time.
Doctor, nice to see you. What city do you live in?
Salt Lake.
I'm gonna take this off. I do have a cold, but
We're far enough away.
what's your current position?
I think if I was plaintiff's counsel, I'd
Currently
be
the
wiping
chief
down the
medical
podium
officer
with like
for
Clorox
Intermountain
after
Healthcare in
he
Utah and Idaho.
questioned.
Does that mean you're the top MD for all of Intermountain Healthcare?
In Utah and Idaho.
Okay. You're pretty young, aren't you? How old are you?
48.
Yeah,
When I hired on you on this
sourcing
case, you didn't have such a prestigious title, did you?
No, I did
sourcing
not.
is hard.
What were you?
I was a neurologist at Intermountain Medical Center and the leader of our neurosciences program at Intermountain.
Good for you.
I might have missed his
To
name
be
'cause I
clear,
was
you are
reading.
not here on behalf of Intermountain Healthcare, is that right?
Correct. My
We-
opinions are my own.
Thank you. All right. Just undergrad, where was that briefly?
Undergrad, University of Maryland, College Park.
In what subject?
Go Terps.
Cell and molecular biology and genetics.
What
Now-
a nerd.
I am a neurologist.
I think I'm offended, but I'm not sure if I'm offended. The lawyer said, "What a nerd." I need to back that moment up real quick. I'm sorry. Also through these trials, it is my goal to know the college mascot of every college they could ever talk about. I want to know. I'm gonna slow this down. And I think I missed his name. Thank you, Miguelina, for catching it. You do better than I do. This is Hash.
What's your current position?
I'm currently the chief medical officer for Intermountain Healthcare in Utah and Idaho.
Does that mean you're the top MD for all of Intermountain Healthcare?
In Utah and Idaho.
Okay. You're pretty young, aren't you? How old are you?
48.
When I hired on
No,
you on
you
this
ju-
case, you didn't have such a prestigious title, did you?
No, I did not.
What were you?
I was a neurologist at Intermountain Medical Center and the leader of our neurosciences program at Intermountain.
Good for you.
What is
To
happening?
be clear, you are not here on behalf of Intermountain Healthcare, is that right?
Correct. My
We-
opinions are my own.
Thank you. All right. Just undergrad, where was that briefly?
Undergrad, University of Maryland, College Park.
In what subject?
Cell and molecular biology and genetics.
What a nerd.
I am a neurologist.
Right, I'm a
Kidding.
neurologist. What?
Poli-sci
Owens.
is the nerd thing. All right. good
No,
for
it's
you.
not. Poli-sci is where lazy lawyers
Your
go to get
MD
to law
degree was
school.
where?
Stop it.
University of Maryland in Baltimore.
And what did you choose to specialize in?
I think I'm annoyed.
Neurology.
Okay, and how many years? So 4 years undergrad,
What is
4 years med school, then how many more years?
He would have done
Well,
a
then I did
fellowship and a
PhD
residency.
for 4 years.
Wait, you did a
as well in
PhD
that
too?
time, and then went across town to Hopkins for my neurology residency.
Then
So
did
that
a
was
residency
another
at Hopkins.
4 years.
He's really
What a
smart.
nerd. All right.
the fuck
4
is
years
happening?
Postdoctorate. What's that? In?
Neurology.
Okay.
And then 2 more years as a fellowship in neurocritical care.
But did you say there were years after undergrad before med school?
No, it was during med school. I did my
What is
PhD.
happening?
Okay. Not all MDs do PhDs too?
This is a highly accomplished doctor,
Okay.
and you're
That's a lot of
snarking at him.
training.
He's your
Fellowship was in what specifically?
He's your expert.
Neurocritical care.
All right.
He's clearly
So
very
neuro-
smart. Why the
critical care.
cringe?
This is like when people hit their head and they're in big trouble,
That's correct.
or they get a stroke, they're in big trouble.
That's right.
They call you in, and sometimes you think you're gonna go swimming for fun, and you just get called in for like 14 hours straight
That's right.
to work on one patient.
Right.
All right, married, kids.
Yes.
Owens couldn't sound more disinterested in this man's life. I'm fascinated. Sir, you did a PhD, then
Have
you
you
went to
reviewed some
Hopkins.
materials
You were the
in
head
this
of an
case?
entire
I have.
large
All right, so the jury just heard from
medical
a
company. My brain blanked on multi-location
neuroradiologist,
medical.
and you are
And
a
Owens is like, what a nerd.
neurologist. Okay, distinguish the two again,
Okay,
really
I'm
quick.
speeding it back up.
So a
because
neuroradiologist reads images, MRIs, CTs, X-rays, all kinds of images of the brain.
And he's a
spinal cord.
neurologist.
Okay, and you neurologists do what?
We diagnose and treat conditions of the.
Well,
of
we
the
know
nervous
nerd is
system, so
cool.
brain, spinal cord,
The way Owen said it was
peripheral nerves.
so
And then
like
this afternoon we're gonna hear from a
aggressive. It's like, what a
neuropsychologist. What's
nerd.
that?
It's like, Owen,
Neuropsychologists diagnose and
I don't
diagnoses and
believe you weren't
treats,
picked on in school.
disorders of consciousness
Why are
and
you being
awareness
so
and
rude?
language that are related to neurological conditions.
And do the three of you work together on hard cases?
Yes.
And do you rely, for instance, upon a neuroradiologist and a neuropsychologist all the time?
Yes.
Okay.
Some of you said, I think Owens is
You know I was
humanizing
kidding
them
when I
both.
said nerd. Really, I'm praising you in a backward way. I apologize if that sounded passive aggressive.
We call ourselves nerds. That's okay.
It sounded aggressive,
All right.
aggressive, Owens.
You were here for Dr.
He came, remember, this is the attorney that came back from a lunch break and said to the witness, I was an ass earlier. So at least there's some self-awareness there. But I feel like Owens would be a real pain in the ass to have as opposing counsel in a deposition because he could be mean. It doesn't come across as funny. It doesn't come across as reverent. It comes across as mean. To me,
Black's testimony.
I'm
on the
open to
neuroradiology. Is that
opposing
true?
opinions.
Yes.
And one of his opinions was that Mr. Sanderson's brain problems
Thank you, Tony.
that he
I'm
complains
here
of
for
as
it.
a result of the collision were actually all pre-existing. Did you hear Dr. Black say that?
Yes, I did.
Did Owens
And
hear us?
do you agree
Maybe.
with that
He
opinion?
heard the
Yes, I did.
internet yelling at
Let's
him.
talk about what you've reviewed. So
Yells in
I
internet.
think yesterday you told me you had received some 3,000 pages of junk. Just kidding. Materials, right?
Correct.
And a big
Today's
chunk of those were medical records, and a big
spicy.
chunk of those were depositions.
Correct.
And then you also received a lot of images before and after.
That's correct.
And did you review all of that?
Yes, over several years.
If Owens had me in his ear, this would go better.
Do you believe you have foundation to render the opinions you're about to render
I
in
have
this
a
case?
feeling Owens would
Yes, I
also
do.
be offended by the
In
color of
addition
my
to what
hair.
you've reviewed, your background, education, training, and experience, do you believe that all comes to bear in rendering the opinions you're about to give?
Yes.
Owens is trying to be funny today, and it's a miss for me. You let me know if it's a hit for you. It's right now it's a miss for me. It could be. Maybe it's the NyQuil.
So, Your Honor,
Or the DayQuil.
I think this will be the most efficient. He's prepared a written report that has some headings.
Excuse
and
me,
I would like to just
sir?
go to and have James
Just
bring
do
up
your
just
job.
the headings.
You just do your job, and then if there's an objection,
Well,
but
it hasn't been admitted into evidence.
Correct.
You can just read them.
Correct.
Have to show the jury anything.
correct.
I think
Are we talking about a demonstrative exhibit
Sykes
to
is right.
illustrate this witness's testimony?
No.
No, we're talking about just the headings of his report.
All right.
Okay, I'm sorry to pause again. Yesterday, Owens and the judge were going back and forth. And at one point, the judge is like, I'm not trying to tell you how to do your job. And Owens is like, well, I wish you would. That was a great moment for me with Owens. I was like, this is hilarious. But Owens is like running by the judge. I'm about to do this. That's not how trial works, Owens. Do your thing. They will object. You don't get to tell the judge. I think it would be faster to do it this way. You don't get to just shortcut it.
Reports are not admissible.
Correct.
Not admitting them.
Agreed, but I think
Then
it
you
might be
can't
efficient to
publish
do it
them.
that way. It's no different than the witness walking up to a chalkboard and writing the words out on a board. So I'm fine with it, if you just show the headings.
Thank you. So, did you prepare a written report, by the way?
Yes, and I have it with me.
And it's broken down into some headings?
Yes.
And I thought this would be helpful. Can you read heading number 1?
The persisting neurological symptoms Mr. Sanderson reports since the February 2016 ski accident.
Thank
are
you,
likely
Chat. You've made me
attributable
less
to
grumpy.
Pre-existing health conditions.
Okay. Is that indeed your opinion?
Yes.
And on what is it based?
So based on my review of the records, his mental health professionals that evaluated him before and after, if you look at the trajectory of those evaluations, it looks
Owens
essentially
is
the same
doing the most
before
today.
and after. Also, based
Yeah,
on
just
review
the
of the
main,
imaging.
just the bullet points.
And afterwards, the neuropsychology testing that was normal, or above normal, compared to population.
And I'm normally a big
Okay.
fan of dad jokes.
Let's
It's
hit
just
all
the
of them, and
setting.
then we'll go back if needed. Are you
We're
able
in
to-
court. Court is.
Well, he brings up number 2.
Court is not for
Comment
yucks.
upon the patient's pre-existing injuries. Which ones did you find particularly important?
The pre-existing condition of depression and anxiety is the most salient.
Okay.
Pre-existing condition.
And
Nuance, I'm
How is
sorry.
it that his pre-existing
Poli-sci is
depression and
also for people who
anxiety
want to change the world. I was a poli-sci major.
is related to his complaints of post-collision symptoms?
So the depression and
I might
anxiety
need
can
a
cause
Snickers,
all the
too.
symptoms that he is complaining of.
I was also a
post-collision.
poli-sci
And
major.
if you look at the records and you were able to remove the collision, just so just make it evaporate, the history reads coherently. This is a
Okay.
man in his
That's
70s with
very
depression and anxiety.
interesting.
And it's gotten bad enough to the point that it's impairing memory and concentration and other activities that he was used to doing.
So is another way of saying that if we removed the collision, he never had a collision that day, it still makes sense, his trajectory?
That's very interesting.
If you read the medical records from before the injury through now, and you remove the injury, it doesn't change the trajectory of his complaints.
So
his
for
evaluation
instance-
by his health professionals.
For instance, if we look at his medical record, let's say just 2 weeks before, 3 weeks before, did you know he went to the VA doctor that day?
Yep.
With complaints of, I'm feeling really old, I can't do what I used to be able to do. That was pre-injury, correct?
Correct.
And then you compare it to his records even soon after the collision. You're saying it doesn't really show anything happened, correct?
Hasn't changed his course.
Okay.
Rotten Ralph,
And whenever you're ready, James,
we get to talk about you being a nerd.
can you read your opinion number 2?
I think
The
that's
only
very
neurological
helpful.
problems, Mr. Sanders.
I object to reading a report to the jury. You can tell it, no problem with that, but you shouldn't be reading it.
We already dealt with this.
Yeah, overruled, I think I ruled on it.
Go ahead.
The only neurological problems Mr. Sanderson has
was-
had.
we
may be
already dealt
partly
with this.
Start over. The only neurological problems Mr. Sanderson has had that may be
I
partly
wish I was a
attributable to the
theater
ski
major.
accident are those associated with the mild concussion he experienced during the accident.
Okay, can you fill in the meat on those bones? Help us understand that a little.
Yes, so my opinion is if he had a concussion, it was very mild. More likely than not, I would say 95% or more that he would have made a full recovery from that concussion within a few weeks.
This has been helpful
Not-
testimony to
more
me.
than 99% within a few months, based on the severity of the concussion. So
I think he's saying, I'm in that like 1%. I'm not in
Objection
the
leading.
95 and the 99%. How do you respond to that?
So I would say if, as as a neurologist, I have patients that come in, they complain of cognitive symptoms, memory loss, attention problems, difficulty doing things that they used to do, and they can have depression and anxiety. They may have early signs of dementia. Those things are far more common for someone in Mr. Sanderson's category. Man in their 70s, they don't feel the way that they used to feel like they're getting old, like he said, before the accident or after the accident, concerned that they may be getting Alzheimer's disease. So I think those things are far more likely than a very minor concussion causing symptoms 7 years later.
Do you see hundreds of those patients a year who've never had a ski collision?
Correct.
Okay, any other comment on your opinion number 2 that you would like to make?
Oh, I'm at 1.25. Yikes.
No, I think that concludes it.
Thank you. James is going to bring up number 3.
Thanks, James. So the key I took from this testimony so far is that if you look at the plaintiff's medical records before the
And do you have it
collision
there?
and after,
I do. Should I
when
just
you
read
take
it?
out
Start
that
reading it.
event,
There you go.
they still
The
make
neurological
sense.
problems associated with the mild concussion Mr. Sanderson may have experienced resolved within months. They were not permanent, as plaintiff's experts claim.
So he's
Okay,
just going
mild
through his
concussion.
opinions.
You weren't here, but did you hear Dr. Edgley testify or read his deposition?
I've read the deposition.
All right. So did he talk about, hey, a couple things we look at is length of,
Objection, this states facts. There's no deposition.
Sustained?
okay.
Testimony?
Comment, I did misspeak, I forgot you didn't take his deposition. Is there some importance in determining
like,
the
"It's the
severity of
Dayquil."
concussion? In terms of how long they're unconscious? Is that a factor?
Yeah, length of amnesia, length of loss of consciousness, or length of confusion.
All right. I think those were the same 3 he said. All right. What do you know about length of unconsciousness?
From my assessment, looking through the records, I don't think that there was loss of consciousness.
Okay. Even if there was some loss of consciousness, it would have been brief. Is that fair?
Seconds, yeah.
And let's see, in terms of, I think, to be fair, I think Mr. Ramon said he was spread eagle, head down, out cold, over 2 minutes. I just want to put that in the record. Not substantiated by any other witness, but did you at least observe that?
What is that question?
Yeah, you know,
Well, Your Honor, I object. He's not competent to assess someone's credibility, and he wasn't there.
Correct.
That's what I'm going
Sorry
to.
about that.
That's not what the witnesses are allowed to do.
Yeah. What do you know about that? Isn't that someone saying longer period of unconsciousness?
Your Honor, he can't comment.
That's
I'm actually trying to
for
help
the-
the plaintiff.
we should-
Go ahead.
He's not asking you to comment on, but the witness, he's asking if you remember reading that.
I do.
Okay. Is the significant time to be unconscious, is that 5 minutes or over?
Yes.
All right. And then comment, you said period of
Wait,
amnesia.
can you go back? What?
What do you understand on that? Length of amnesia. What do you understand?
The period of time that the person that has the injury is not able to remember either before.
Are you acknowledging that Mr. Sanderson had a mild concussion?
More likely than not, he did. He had headache in one of the, I think it was the Instacare report, and so that would be consistent with a mild concussion.
So
And it
he's saying
resolved within months? What do you base that on?
even with a mild concussion,
I believe there was a
the
report where
after
he said
is
it's getting better.
still,
Okay, and they are not permanent.
the after
as
effect
plaintiffs
is
claim.
still
Please
caused
comment.
by what he had
Correct.
going on
So-
before the accident, not the accident.
I
I think that's more helpful
The head injury was very
testimony.
mild. I mean, it fell in the most mild category of concussion, so kind of a grade 1. And the rest of the symptoms that he has, what could be caused by other conditions, which I would say are more common.
And do you believe that more likely than not, that is why he continues to have some symptoms?
Yes.
In other words, not because of the ski collision, but just because of his aging progressive brain.
Correct.
Let's read your 4th opinion. There are a total of 6, by the way,
I think that that's
and the latter 2 we might just
clear,
touch on briefly.
and I think it makes more sense for their
The
experts
fourth,
to acknowledge he might have
opinion
had a
is that
concussion
Mr.
than to
Sanderson
argue that
does
he
not
didn't.
currently need ongoing neurological treatment
That's related to the ski collision.
that's related to the ski collision. So I have to modify that slightly because this report was written before the assessment by Dr. Goldstein was available to me.
Right. Goldstein, I think, recommended some care with regard to dementia.
Correct.
Did you hear that personally?
I didn't hear it personally, but I read it in his actual report from when he evaluated Mr. Sanderson.
Do you believe Mr. Sanderson to have sort of dementia symptoms?
Yes.
Your Honor, it's never evaluated him. Can't possibly comment on that without a clinical evaluation.
That's a speaking
No
objection.
foundation.
Owens.
Is it in the report? Do you have symptoms? So he's commenting on his further needs, and he's commenting on,
Is it in the report? Is
Sam
it in the report
Goldstein.
was the
Nothing
question.
in
Why don't you
report.
ask the question,
Nothing in
then we'll
report about
see.
Judge.
Go ahead and ask your next question.
Is it in the
Okay,
report?
so you said Mr. Sanderson does not currently need ongoing neurologic treatment, true?
Correct. That's what the report says.
Okay. Since you wrote this, did you then read Sam Goldstein's updated opinion?
Yes.
Objection, Your Honor. Can't offer new opinions.
Sustained.
Thank you.
Is there a drug that treats dementia?
Yes.
What is that called?
It's called
Your
Aricept.
Honor, I object. There's no opinion on dementia.
Sustained?
Thank you.
Owens is trying to get into things he
Why is it your
can't get
opinion that
into.
Mr. Sanderson does not currently need ongoing
And he can't.
neurologic treatment related to the ski injury? Is
There
the
are
issue?
rules.
Ski
Owens.
injury caused a mild concussion, more likely than not, that was self-limited. And his ongoing symptoms are more likely due to
We're at
ongoing,
1.25 speed.
pre-existing conditions and possibly new conditions.
Let's bring up, if we can, D106. I don't think so.
Owens pushes the bounds of
objection?
what's proper to be admitted.
This is for demonstrative purposes only. Sure. Okay. That means we can also write on it, can we not?
Why don't we address that if we need to
But it's
later?
on the back of an
So
exhibit.
just-
You
Defendant's
can't put
Exhibit
a,
106 is received?
you can't put a demonstrative on the back of an exhibit because the exhibit goes back to the jury. What is happening?
I want to make sure you can see it. And James, if you can bring it up, that would be good.
Owens is following his own rules of court here today.
Okay.
D106, James. All right, you see it?
Yep.
Have you had a chance to read this document?
Yes.
And do you agree with it?
Yes, I do.
I didn't notice that,
It's entitled,
Crystal. Thank
Mr.
you.
Sanderson's brain imaging both before and after ski collision. Did it show atrophy, loss of brain cell sign of aging brain before and after?
Yes.
Did his images, I actually have a roaming microphone, but maybe it needs to be higher up. Volume
Oh,
loss,
gosh.
diminishing brain size, sign of aging brain. Did he have this before and after?
Your Honor, I object to this testimony. This witness is a neurologist, not a neuroradiologist. I don't think he's competent to comment.
What's the objection?
on, radiology.
Outside the scope? Outside the designation?
Foundation, if you want.
Go ahead.
Do you look at images all the time, all day?
All day, every day.
So the neuroradiologist reads them, but do you just rely on their written report, or do you personally read them too?
I look at the films, then I confirm with their report, and then I bring it together with what we see clinically.
So I think the objection is somehow that you're not competent to
So why
talk
are
about
you
the
commenting on the
imaging before
objection?
versus after.
Just
Do you
ask the
agree or
question.
disagree?
I disagree.
Just ask the
Also,
question.
So I've looked at the images. These are pretty standard MRI images that we see every day. And a major part of my practice as an outpatient neurologist was evaluating patients for dementia and specifically NPH. Saw hundreds of patients with the question of whether they
Not
had
Neil
NPH.
Patrick Harris.
Hydrocephalus.
It's the hydrocephalus at the bottom.
All right, so is it true that neuroradiologists essentially serve you? They don't personally
What
talk
do you
to
mean by
patients?
serve?
You order the neuroradiologist to do a study, then it comes back to you, and you are the one who's face to face with the patient.
They work together?
I translate the.
Just a second, sir, I'm sorry. Sustained as to leading.
Okay, have I established sufficient foundation?
This does have the scientific, technical, or other specialized knowledge that'll help the jury, so you may proceed.
Okay, we talked about atrophy and volume loss. Enlarged ventricles. A ventricle is what in the brain? Is that like at Halloween when we see a mold of a brain? It's the little gooey stuff going out? You tell me.
No.
Okay. I was
It's
totally
the,
wrong.
inside the brain, there's fluid-filled sacs that contain spinal fluid.
Oh, God.
So
Okay.
it's the black thing in the middle on the MRI that Dr. Black.
It's the
went through.
sacs. It's the,
All right.
the
And
fluid.
Is that
filled-
like the main blood feeding the brain? What are they?
No, the,
What purpose do the ventricles serve?
they buoy the brain, so it prevents the brain from having as much shock when we just move around in everyday life.
All right. Chronic microvascular
My brain
disease,
feels
is that
buoyed.
something he had
Yes,
before
it's
and after?
it's
Yes,
goopy.
that was described by Dr. Black.
It would have been better if he said goopy.
Is that associated with cognitive decline?
That would have
It can
actually
be.
been funny.
And why does he have that? Is that from this stroke event years earlier, or just bad luck, or eating too many donuts, or what?
I think it's a combination of his high blood pressure.
Leave
and high
donuts
cholesterol
alone,
with
Owens.
a little bit of genetics that makes our blood vessels harder than average.
White matter disease, we've talked about that a little bit. It says they're damage to nerve fibers associated with memory, balance, and mobility issues. Did he have that before and after?
Yes.
And is that progressive in nature?
It didn't look that like
I can't
unbelievably
see the
progressive,
expert.
but it was
Owens
stable
put
over
the
time.
put
Why
the.
did he have
I know
that?
the
Was
jury
that
can see
associated
it, but
with
Owens
stroke
put this
event?
in the strangest
No, I think
place for a
it's probably
streamed
associated
trial.
with the chronic microvascular disease. The stroke event was in his eye.
No evidence of trauma before or after, is that true?
That's correct.
Concern for disease due to excess fluid buildup. That's the NPH. Was that a concern before and a concern after?
Yes.
Does he in fact have that condition?
So that would be a condition that I would need further clinical evaluation to determine. But
Ellen,
his
the
MRI would
chat
be
has asked
consistent
us
with
for
that.
days
You mentioned earlier that
because it seems like it wasn't impacting him that much.
his conditions are not permanent, as plaintiff's experts claim. And I just want to comment, do you believe Dr. Fong to have used unreliable science to make some of her opinions?
Objection, leading. Sustained as relevance.
Remind me how long Owens said this would take. He said a half an hour. He said in and out in a half an hour. Have we been timing him?
Hold on, sorry. Thanks.
They're about to get up and criticize you for not seeing this patient. Why
Just do that on redirect.
didn't you? Why
Oi.
wouldn't you? Why would it be necessary if you needed to?
Redirect because he did a
Yeah,
doc
well,
review.
I would always be willing, and actually didn't know that was an option. But in this case, and with many patients in my practice, we review tons of records before we see them. And actually, Mr. Sanderson probably had 10 times the amount of records that I have before I see my patients in clinic. You said 3,000 pages.
He did have
and
a
lots
lot of
imaging.
records.
So I can know with 90% certainty going in based on the before and after imaging, the neuropsych testing over a period of years, his reports over time. I can know with 90% accuracy what's going on. So if I went in there, I'd be trying to figure out, does he have NPH or not? And what can I do to help him with his
And then it would be
depression,
imaging, right?
anxiety, and other memory problems?
Would you be treating him
Interesting.
or evaluating the ski injury?
No, I'd be providing counseling that the ski injury was not part of it.
Oh,
Now, you
Therapy is the
refer
answer.
people all the time to neuropsychologists, is that true?
Yes.
And we're about to hear from two.
Two?
But you did have the benefit of multiple neuropsychologist exams at the VA, is that true?
Correct.
And do you know them to be good neuropsychologists?
I don't know them.
Okay. Do you
Was
know
he
them
able
to
to
be
rely on their
not
reports?
hired by either side
Counsel, he
as
said he
normal
doesn't know them.
treating providers?
Yes, that's my understanding.
And these were voluminous evaluations, were they not?
Yes.
And what did they conclude?
Owens does a
They were
lot better
essentially
when he
normal,
sticks to
and they showed that
questioning
he
like
was
this.
performing above average.
Small steps.
Now, is that above average for everyone on
much-
the street or for
much better questioning
75-year-old men
than when
with
he's trying to be
college
quippy.
educations or what?
For a 75-year-old man with college educations and
Okay,
with,
so
with a high baseline.
so in some places even like near superior
Correct.
levels.
Yes.
So I'm gonna grab one thing.
when he keeps his questions simple and walks through the this and then this and then this and then this, it is much easier to follow. When he tries to put it all into one question as if he's doing a
I think the jury's
deposition,
seen various
it's much harder to follow.
neuropsych overviews. But do you agree he was tested in tens and tens and tens of categories?
Yes.
Did you see any of them below average?
No.
Did you see many above average?
Yes.
Above average is the
IQ,
word
for
you
instance,
wanted.
was 114, is that right?
That's my recollection.
And for like a 75-year-old man with a college education, is that good?
Yeah, it's above average.
Okay,
And
what's
that's the
average
word he
again?
wanted was above
100.
average.
Okay. Now, I think they're gonna say,
He
hey,
used
the
superior.
family members are.
The word he wanted was above average.
Saying, we're noticing he's angrier than
I've
he used
got
to
to take a
be.
call
Or
real
that he can't, drive and read at the same time. There's things he can't multitask with. Can you comment on that?
So, you know, in people like Mr. Sanderson who are high functioning at baseline, you know, above average IQ, you know, superior in some categories like you described, you know, a drop in functioning might still look like he's really high functioning compared to the average population. And the family will pick up on some of these changes, right? They see what they see. Yeah, that concludes that.
So if you did meet with Mr. Sanderson and he kept obsessively bringing up, I think the ski collision caused this, what would you say?
I would say that it's my job as a neurologist to help him accept that that's not part of what he's experiencing now. More likely, way more likely than not, he has a history of depression and anxiety. We know he continues to be anxious, so that needs treatment. And I would, you know, evaluate for dementia, like we said, as would be indicated by his imaging.
Okay.
And so my job is to help the patient and family gain acceptance that this mild event 7 years ago isn't causing all these problems that he's having now.
Or any of them.
Right.
Didn't you tell me the cure for Mr. Sanderson is the end of this lawsuit?
Interesting.
No foundation, relevance, improper questioning.
Overruled.
Go ahead.
It's a good question.
Is that your opinion?
Yeah, I mean, I felt anxious coming here.
I also object. That's not in his report. Nowhere to be found.
Overruled.
Go ahead, just explain that and then I'm sitting down.
I mean, you know, suing somebody, going through a trial that has, you know, national recognition can bring on a lot of anxiety. And if you're prone to that, it's gonna make it worse and it's gonna slow your recovery.
His daughter said this notoriety makes him feel powerful. Did you read that in Jenny's deposition?
I did.
Objection, Your Honor. Jenny's deposition is not in evidence.
Sustained?
This expert's,
Into evidence,
I
counsel?
disagree with the court. This
If we have
expert's
time,
allowed
we're
to
gonna
rely
read
on
it in.
Well,
This expert's allowed
It's
to
been
rely on
referenced
it,
multiple
though.
times.
Here,
But
yeah.
he's an expert. He's
if-
allowed to rely
if
on
you're
it.
planning
I
to
disagree with
ask
the court
this
on that.
witness about
Owens
evidence
is right
that's not
to
part of the
on that.
case, or won't be part of the case, then it's an improper question.
Okay, if he's read it as part of his opinions, experts can rely upon hearsay.
They can.
They
Yeah,
can.
but it's not referenced in his report, Your Honor.
Well, if it's not in his report, then sustained.
Then
Okay,
that's a
I'll let you
problem.
go. Thank you.
But experts are
Mr.
allowed to
Sykes.
rely on hearsay. Mr. Sykes was like, it's not in his report, and that's the thing. What they rely on has to be in their reports, and that is something different in civil. In criminal, you don't have reports quite like this, and things are a little more fluid. In this, the expert's report is the end. They cannot go outside the four corners of that.
Doctor, do you commonly
Terry Sanderson is still in
render
court.
opinions on your patients without a clinical exam?
No.
This is exactly what they're going to
In
talk
the
about.
last 100 patients that you've seen, or that are referred to you, how many have you rendered opinions on for other doctors without an examination, a clinical exam?
So I mean, we do have conversations with other doctors where they say, hey, you know, what do you think about this case? And I may render an opinion without
But
seeing
that's
the patient.
a
But if it's my
consult.
own patient, then it's part of my standard evaluation to see them.
A
If it's your own
consult's
patient.
different.
Your last 1,000 patients that were your own patients, you would never render opinions about them without a clinical exam. Is that a fair statement?
No,
Never.
I would form an opinion, but I wouldn't create a treatment plan and execute on it without seeing them.
So a clinical exam, would you agree,
I think that's fair, a fair
for this
portion.
jury, is an important factor for a physician?
Correct.
Yeah. No.
I like this expert.
Did you read the opinion
like
that Dr. Edgley
the
testified
way
yesterday?
he's answering.
The,
He's not backing
no, I did not.
off.
If he called a clinical exam the gold standard for a physician, would you agree or disagree with that?
Overruled as to relevance, the jury will recall the testimony of Dr. Edgley.
Well, in all honesty, he didn't say it in his testimony, he said it in his report. I'm asking if he said it in his report, would that make a difference?
Your
Trying to be
Honor,
honest
that's
here.
referencing testimony that's not, there are no facts and evidence.
I will draw the question.
Thank you.
But would you agree, excuse me, that a clinical examination is the gold standard for a physician who's treating somebody?
I'm not sure what a gold standard means.
Pretty
But
important.
It's a big part of my evaluation.
Excuse me.
Sorry to everyone's ears. I apologize. I didn't know that was
Secondly,
coming.
I'd look
can't
through
see
your
his
opinion
face.
pretty carefully.
We're
It's
caught up
about
to live
4 or
speed.
5 pages. I noted, let me see if I can get it here handy.
So with this, experts are allowed to rely on hearsay.
you remember
They're
this.
allowed to talk about, I considered this person's testimony, I considered this person's
It's on
thought.
my computer. But
And
you
that's
had a
what we're getting
list
to.
of things that you reviewed, is that right?
Yes.
Okay.
Yeah,
Can
this
you tell this
microphone
jury,
needs to be disinfected from
a
everybody.
summary of what Carlene Davidson said in her deposition about Terry before and after the ski crash?
I can't from memory.
You're
Okay.
gonna have to show it to me. And they don't want to show it to him
Can
because
you
they don't
tell
want to
the
spend the
jury-
time to find it.
Holly Gresham, the daughter, said about Terry before and after the ski crash.
Yes, I did read Miss Gresham's deposition this weekend, or her statement.
But you didn't read Carly Davidson?
I think I did, but I can't remember all the names. If you want to show it to me,
He
I
said
can
it was a
comment
lot of
on it.
records.
Tell the jury, if you can, what important information about Terry before and after the ski crash Polly Gresham said.
So she
summarize.
feels that he, is not as engaged and able to do things in the way that he used to. I think that's probably the summary.
That's a pretty mild statement of it, isn't it? Didn't in fact she say?
Wait,
Polly
let him
Gresham,
answer.
Daughter,
No, let him answer, counsel.
excuse me,
Let him answer.
that there was a marked and sudden difference in her father in a wide variety of areas: personality, executive functioning, social problems after the ski crash, almost immediately. Didn't she say that?
I'm not sure she said executive functioning, but the rest of it sounds familiar.
Did you
We
read
know, chat, we
Shay
know he has
Harris'
a cough.
deposition?
If you, we
Remind me
timestamp,
of the
if
relationship.
you need to come back,
Daughter.
we know he has a cough. We
No, I
know
did not.
he's had it the whole time.
Okay.
Please don't.
Those
try to
three are
diagnose his
listed,
cough.
and you.
It can be frustrating to listen to, I get it, but thank you.
I read it, but I can't remember what it says.
You read it, but you can't remember it.
I had to turn him down because he's yelling into the mic.
But tell the jury if Shay Harris is listed there as
So
one you
thank
had.
you. We all know.
SHAE.
He
I don't
is
see it.
yelling. I like Bueller's demeanor better. I think I heard an objection, but I'm not sure. But he does have an aggressive style. Kimberly asked a great question earlier. Do judges only do one type of trial, civil versus criminal? It depends on the jurisdiction, and it depends federal versus state. So it depends. In some jurisdictions, it's mixed. In federal, it's mixed. In some jurisdictions, it's split. You're either assigned to criminal or to civil. I think split. I prefer split. I think civil attorneys also prefer split. But it really just depends on the jurisdiction. There are things that happen in civil that don't happen in criminal. So an attorney that's done criminal their whole life and has never done civil, some of the civil quirks are just something they've not experienced. And then there's lawyers like Peter Targos, who, if he ever became a judge, has such a wide variety of experience, he would be able to easily navigate between the two. So I think a lot of lawyers prefer
Let me show you what
split.
you wrote.
Can
So
can
we'll
we
see.
move to admit our report?
Just for illustrative purposes, I want to show him what he wrote.
Thank you, V to the seventh power.
I guess I don't, you may be
Congratulations on
opening the door to the
graduation.
report.
You wanna do that? Okay?
You are joining a
Take a look
storied
at it.
profession. I'm sure you'll be
Items,
excellent.
4, L, M, and N.
This dude is so mad. Did I pronounce
Correct.
Peter's name wrong?
I don't see Shay Harris, like you said. I think that was the question.
Probably did. I'm sure Peter will forgive me. Lawyer, his channel's lawyer, you know.
Okay. You know what?
I will
You're right.
continue to pronounce things
You're-
improperly.
You see Carlene and Polly.
I love, you're right. Targos, Tragos,
The
Trey.
defense did not give you Shay Harris, right?
Correct.
Hypothetically, if Shay said there was a very
For me, personal opinion, my opinion, it is always a bad look on either side when the experts don't get all of the reports. It always, to me, makes it look like they're hiding something.
So, the defense did not give you
So do I.
Shay Harris, right?
Correct.
I think that's a bad look.
Hypothetically,
I
if
don't
Shay
like it.
said there was a very, very sudden change in my dad
Happy birthday,
before and
Sassy
after
J.
for what we call neuropsychological symptoms, would that make a
Happy
difference in
birthday,
your
Divine
opinion?
Aries Goddess.
It might have made a difference at the time,
Cheers.
Okay.
but at this point in time, it would not.
Get your goddess energy on your birthday.
Carlene Davidson testified. She was a second witness in the trial last week.
And it's Aries season.
Does this ring a bell that she was living with Terry for
They should
about
get
a
all
year
of
and a
it,
half
though.
before the ski accident? Does that ring a bell?
That
They
does.
should just get all of it and then they
And
decide.
she's up here about 300 days a year in Salt Lake.
From St. George, right? That was, yeah.
And they also spent time in St. George together.
Yep.
They should get all of it.
And they went on international trips together.
Yep.
Is that right?
Yes.
Do you think she would get to know him pretty well during that time?
Yes.
She testified that there was a rapid and severe change in Terry after the ski crash that lasted, and she stayed with him for 6 months and then they parted ways. She said she was heartbroken.
Giselle, thank you for this.
She was hoping for a marriage out of this.
Your Honor, this compound.
Sustained?
It is
She
compound.
was hoping for a marriage out of this. Do you remember that in her deposition?
Yes.
Yeah. But he changed fundamentally after the ski crash. Now, does that make a difference in your opinions at all?
I mean, it would be part of the whole compendium of what I would put together. Yes.
I didn't read anything about that. I read your report. It's about 4 pages. Aside from their depositions
It's in my
that
Amazon
you
store,
referenced,
Stanley.
you don't say anything at all in your report about the rapid and fundamental changes that occurred to Terry after the ski crash, do you?
These are fair cross
Don't even mention
questions.
Is that correct?
That's correct.
Now,
Thanks, Sky.
are you familiar with the term executive functioning?
Yes.
I think Judge would be
Is that
great.
something that neurologists use, a term that neurologists use?
Sometimes. Yes.
Yeah. Because you realize, of course, as a neurologist,
I wish
that
you
you can
had
have
started with some of those questions.
massive changes in a person with a mild TBI that don't show up on imaging, right?
Yes.
Good
That's
questions.
Yeah, you mentioned that earlier in your testimony. And a category of those changes is called executive functioning, right?
That is one manifestation potentially. Yes.
Executive functioning, we
That's
don't know
one
her.
Yeah.
What is that like?
And I didn't see the word
the people
executive
that
functioning
manage
even
to
addressed in your report.
pay their
Not even a mention.
car registration on time. Those
Sorry, is that
folks.
a question or
Yeah, correct.
What's the question?
With a inflection for a question. Yes.
Is it in my report?
Yeah.
No, it's not in the report.
Okay. Hey, Pete, would you?
Hi, Fred. And Bought for Love, that's been one of my complaints about the defense team particularly, is they do comport this trial as if they're at a deposition and there's just a lot more people present, which
Now, while
I
he's doing that,
is odd to me. It's just
could you
odd to me.
define for the
Trial
jury
is different.
executive functioning
There is a level of
in a medical sense?
The
formality
ability
and solemnity
to do
to
things,
it.
to start actions and carry through with them.
To start actions and to what?
Hi,
Sorry.
Carry the actions through.
True, yeah. That's self-regulated, self-directed action, right?
Correct.
What's self-regulated like?
And that people use that to manage
Right.
their affairs effectively.
Want to say
right.
hi?
Yep.
No?
Have you heard of Sam Goldstein?
There's something fascinating outside my
I know
window.
of his report, as I testified earlier, and I read some of his deposition. Actually saw his testimony.
He testified here.
Fred, the chat says hi. Fred is thrilled.
And by the way, were you aware that he is a world-renowned neuropsychologist from Salt Lake City?
Yes.
Yeah.
Yes.
And he developed
He is
an
world
executive
famous.
function test.
Correct.
Can you see it on your screen there?
I do.
I want to know what my rank would be.
And here's what
I need to
he
retest
recorded
myself.
with a high
Organization,
confidence level.
weakness, me. Planning,
this
weakness.
man, Terry
also me.
Sanders-
Working memory, weakness, probably me.
Who was a former captain in the United States Army, ran
Not
eye
colonel.
clinics for the Army, has an advanced degree in optometry, which I think is a 4-year degree.
Get off
if
that
I'm not
camera,
mistaken.
Fred.
And ran 2 clinics in southern
Fred.
Idaho. Okay? Would that indicate to you a man of superior intelligence and executive function?
Above,
Yes.
Can we go with above
Let's see what
average?
he did here.
Can we just,
Okay.
can we all?
Strange, or just average, by the way.
Fred!
25th percentile. In other words, out of 100 people, he's 25 lowest, right?
That's correct.
That's what that means. Yeah.
Yep.
That for a man of his attainment, he's only the 25th percentile in attention.
Come here. Off the camera.
World-renowned neuropsychologist
I don't have
recorded this.
Toy for you.
Does that strike you as odd?
Strikes me as him having issues like we talked about. He
Let's
has
go to.
medical condition.
I'm sorry. I'll skip emotional just to.
My
I'm saying
cats are.
I think these are
sass.
data and they're good data, and it reinforces my stance that Mr. Sanderson needs help. He's got depression and anxiety, and I think this could be consistent with dementia as well.
Okay. By the way, let me show you our exhibits.
So for those of you asking, no, the court hearing with Sheena Shea is not going to be televised today. I don't even know if it will happen because I think Raquel's going to drop that restraining order. Just for a quick sidebar.
Yes.
Quick sidebar on the chat. It's not going to be recorded, and I think nothing will happen. I can't
Do you
hear
have the number of
anything.
that?
Yeah, it was 43.
Sir, could I just ask what date this is?
Okay.
Was this 2021?
Foundation.
Susan,
Your Honor.
the chat is on slow mode because we have almost 30,000 people in it. Members are not slow moded. Oh, Gwyneth Paltrow likes flare pens. I like flare pens too. They're some of my favorite. Sorry,
Defense
ADHD.
exhibits and plaintiff's exhibits.
I love flare pens.
Can you show us where there's a diagnosis of dementia?
Yep,
This
good
is
use across.
going back to 2009 and up through, I think,
This
2021.
needed to be
What
addressed.
hasn't been made yet?
This needed to be
Hasn't been
addressed
made.
because
Okay.
we've been asking it
So,
for days
you would agree, for the jury's
in the chat.
help here.
Is this something that's is
despite
this
the fact
something
that we're
that's
in
a factor here?
Very important worldwide case,
Yeah,
okay? Like you
Paltrow is
mentioned.
using purple flare pens.
Paraphrasing your words. There's no diagnosis of dementia.
I also really like the precise V. I like pilot.
Hasn't been made yet. Yeah, because we're talking about a minor brain injury that happened in 2016
Okay.
and not allowing him to move on to have a true diagnosis.
Let's talk about flexibility. Exhibit 43. Low average, 23rd percentile for flexibility of a man who ran 2 clinics in southern Idaho. Does that sound really low?
A lot of doctors aren't flexible though.
Sounds low.
To be
Yeah.
fair,
By the way, you asked me the date. I think this was done in 2020.
these are
Okay.
flare pens. The little these.
I think it's 2020.
All kinds of colors.
Okay?
Yep.
Uh,
Papermate.
It's just
They're great.
organization. Now, the ability to organize things is a very important part of executive function, isn't it?
Correct.
Very important part. Third percentile. Third percentile.
That's why us ADHD folks have 7
I'm a
planners
simple
going at a
country boy.
time and are always looking
If that
for
were
a
me,
new
I'd understand
system.
it. But I didn't run 2 clinics. Okay?
Yeah.
Third percentile. Does that strike you as indicative of something wrong here?
This attorney seems
Yeah.
to be trying to signal to the jury they should be
Planning.
outraged
Oh, by the way,
by these
below average.
preposterous
Below average.
claims in his testimony.
Excuse me, planning, 4th percentile. Below average. Does
So
that strike
Betty,
you
that's
as
why
very low for a
he's
man of his
signaling
attainment?
to the jury
Very
that
low.
they should be outraged by this
Self-monitoring, 10%.
preposterous testimony.
That strike you as very low for a man of his attainment.
It does.
What about working memory? For a man who did everything he did.
We're going to hear anything about ADHD
Working
in the
memory
chat.
of
Not the chat, in the
5%.
trial. Are they going to talk about it at all?
It's low.
Many people have
Right.
ADHD and
Now-
are very successful.
Can we make one more comment on that, by the way?
Well-
Or do you want to move on?
Oh, let's just move on.
It's related to Goldstein's report.
What's that?
You know, my impression from Goldstein's report is that that's why he was recommending the cholinesterase inhibitor, is based on these kinds of findings,
Well,
which is a treatment for dementia.
if you don't remember specific
This
things about
doctor
his
thinks-
executive functioning from his family, do you?
Okay.
No, I don't.
Yeah. Or from Carlene. But Carlene told this jury just a week ago
I figured that was
there
going
was
to
a
be the case.
major change in these things overnight, and she couldn't live with it. All right, now
That's not what I remember her saying.
excuse my cough here. I don't get a cold very often, but this is a killer.
All the attorneys in this
Did
courtroom
you
are
see
sick.
anywhere in these records? Okay, now let me just preface this. Terry Sanderson has been a patient.
It happens a lot in
Of,
trial that lawyers are sick, by the way,
Veterans
because of the
Administration. He was a
work that
veteran.
goes in pre-trial.
I think for since the early
It's
part
not
of
uncommon. It
the
just,
century, early 2000s. When he moved down here from Idaho.
Right.
And he's got a lot of records there. And there are a lot of records that you read after February 16,
Keystone,
26,
study
of
attorneys
2016.
being sick in
Correct.
trial.
Now, in those records, do you
High
see
stress,
anywhere,
low sleep.
anywhere, accused of faking, malingering, or magnifying symptoms for money?
No, sir.
Nothing there, is there? Okay. Nowhere where he says, I'm in it for the money.
No.
And did you read the reports of Goldstein, Fong, and Gibby?
I did. Yeah.
They're all treating physicians for him.
Correct.
You aware of that? Treating.
Yes.
Okay. They're all pretty competent, aren't they?
Yes.
Dr. Fong said she's treated thousands of patients with
I liked
mild
Dr. Fong.
TBI. You aware of that?
I wasn't aware of the number, but I
Yeah.
know that she treats.
She
mild
missed
TBI.
trial here because she's lecturing over in Holland on what she does. She's lecturing in the Netherlands.
I want to go to the Netherlands.
You aware of that?
No, I'm not.
I think she was going to Spain after that. Anyway.
That sounds like a great trip. Where else was she going?
She said, and by the way, are you aware that these kind of doctors,
Wait, no,
at least
finish
the neuropsychologists, they give tests that have embedded,
Can we finish the last question?
cleverly embedded tests for malingering? You aware of that?
I am. Yeah.
And neither the VA or these 3 doctors found any suggestion
We all want to go to Europe.
of faking or malingering or magnification. Or you aware of that?
Correct. I
Or,
agree.
or any suggestion that he's doing this for money.
Right. I didn't.
It's an
Her travel
insulting
plans
comment. But there's no
are
suggestion of that, is
showing
there?
how
see
prominent
any
she
of
Do you
is.
think he's doing it for money?
I don't know. I have no opinion on that.
Thank you. Now, with respect to,
Lots of you in the chat in the Netherlands. I appreciate y'all.
you had
There was a
thing up
bunch
there
of you
about
from the
his,
Netherlands in the chat. Hi, everybody.
his CT and MRI.
Y'all are
on that
welcome
chart.
if you want to drop
Correct.
your flags in the
And you
in the
saw
chat.
Dr. Black,
Either where
Yes, I did.
where
his
you're watching
testimony a few
from,
minutes ago.
Yes, I did.
where you are
Okay.
from.
And
You're welcome to. Happy
remember
to see
him
them.
saying that from 2009
Lots
through
of our international
2021,
audience here today.
there's no indication of a change on these scans.
Correct.
Yeah. So, there's no deterioration. That's the big point. He hasn't deteriorated on the scans, has he?
Correct. That was Dr. Black's testimony.
Oh, it's so good to see where y'all are watching from.
And you agree that he had a mild concussion?
Correct. More likely than not.
Likely not. Okay, that's good enough. And you also agree that he's got, and I think in your report, you said, Mr. Owen said 1%, but you said 5% of people with
Did
this
say that.
condition, mild traumatic brain injury, do not recover completely.
Correct.
Okay, now,
So there's a chance.
do you think that an executive functioning outcome like that is more toward
I
the
see the pirate
5%?
flag.
What do you think?
I don't.
You don't?
No.
Okay. Is the fact that the people that love him, that know him the best, say there was a significant and sudden dramatic change in him after this ski crash, do you think that moves him more toward the 5%?
I don't.
You don't? Okay.
And
Do you think the fact that
That's
no
right.
one has diagnosed him with any other condition like dementia moves him more toward the 5%?
No.
You think that the fact that no one's diagnosed him with faking, malingering, magnification moves him more toward the 5%?
No.
Okay.
These are helpful questions on cross.
You talked about
You just said
atrophy in the
Andy
aging
takes the
brain.
5%. I am
Yes.
dead.
That is a normal condition, right?
It can be.
And it's asymptomatic in many people,
It can be.
okay?
That 5%. That 5% is not going away.
Yeah, one more question. I'll talk to my compatriots back here.
One more.
Are you familiar with the pre-existing exacerbation issue medically with brain injury? In other words, let me explain that. If you have a pre-existing, let's say you have a problem with anger regulation
Pre-existing condition, and then a thing happens, and then it's worse
or some other
because the thing
negative
happened.
quality, okay? That oftentimes a TBI, even a mild TBI, can exacerbate those symptoms. You aware of that?
I am.
And that's a true principle of medicine, isn't it?
Correct.
Okay, 1 second.
Wait, didn't you finish the thought, though? Finish the thought. So if he had all these things before, the accident could make it worse afterwards, because the before and after witnesses were helpful.
Would you agree that a person who's had a concussion is at greater risk if they have another concussion? Second injury syndrome, they call it.
Yes.
Okay. That's all I've got, Judge. Thank you.
Thank you.
Okay,
Mr. Owens?
Mr. Owens. Where are we going, Mr. Owens? I would keep it short and sweet.
Your Honor, can you take this down?
Take what down? Oh, the laptop. Mama of boys, I was wondering the same thing. Where was the first concussion?
James, are you hooked up? Thanks. In our last witness with Dr. Black, we actually referred to a document, plaintiff 33,
Yeah, I
page
don't-
8 and 9.
I don't know if Terry had a
And it
previous
was
concussion.
admitted.
They've never talked about it.
And we're gonna And maybe just bring up just number 2, if you would. I don't know if are you able just to clear number 2? Do you remember, this
I'm
is
sorry, I'm a
part of
child.
Dr. Fong's document?
Yes.
And
I've gotten
do
a
you
bit
recall
punchy
plaintiff's
on this
counsel
day
say,
of
show
trial."
show me in those records where it says the word dementia.
Yes.
All right, so let's look at
Did you
this. The
deliberate to
most
clear that
likely
number 2?
diagnosis for this appearance is normal pressure hydrocephalus. The differential would include normal aging brain,
Thank you, chat.
Alzheimer's, dementia,
I'd forgotten.
subcortical arterial sclerotic
Thanks, chat.
encephalopathy,
Nice.
and multi-infarct dementia. All right, this
was
is
good.
plaintiff's own retained expert, right?
Yeah.
And she's talking about, hey, could be some dementia stuff going on here, right?
Correct.
Objection, Your Honor. That's a differential diagnosis, and it doesn't suggest it's going on.
That's a speaking objection, Your Honor. It's inappropriate.
It's an inappropriate,
Overruled. You can cross-examine the witness,
And
counsel.
then, Peter, if you can hear my voice, come back in. I had him go make some copies of another dementia reference that we'll pull up in just a minute.
Do you
Peter,
remember
come back!
Any reference in the VA?
Peter,
where
if
the
you can
patient
hear the sound
actually
of my
came
voice.
to the doctor and
Return,
said, "I'm
Peter.
worried that I am
Accio,
getting
Peter."
dementia."
Yes.
And what do you recall? I think that might have been his.
I know.
treating
Owen's complaining about
psychiatrist,
speaking
Michael
objections.
McIntosh.
Floors me every single time.
Does this sound familiar?
I think that's right.
And-
Every time.
Do you recall Peter making copies? But do you recall what he responded?
Making
I don't.
copies.
Okay, we'll pull that up in just a minute. In terms of how close these daughters were in their personal observations, did you observe that Polly Graham Sanderson had not even seen or talked to her dad for 3 months prior to this ski collision?
Yes.
objection leading.
It is.
Sustained?
They all lived out of state. Is that fair? All 3 daughters lived out of
Just
state.
keep objecting to
from him.
leading.
Your Honor, that's beyond the scope.
It's
Overruled?
You were
Yes.
better with leading. Because he does. He leads and leads and leads.
And he had, in fact, at the time of the ski collision, he wasn't running a 2-office optometry visit. He'd
Fred!
been retired many years, correct?
Correct.
And there's been evidence that he
Fred
left
found a toy.
on bad terms with his partners.
Objection, Your Honor. There's no evidence of that, and it's beyond the scope.
Oh,
Overruled?
He
That's
testified
irrelevant.
about it.
Do you recall this?
I'm sorry, I don't recall that part.
That he left on poor terms. He left his community on poor terms, his business. I'll clarify my question.
Because it wasn't about his business.
So
it was about
I
the
don't want
affair,
just
Owens.
continuing speaking objections.
Mention that.
Sure.
What you want is irrelevant, Your Honor. I don't want continued speaking objections. And the defense is like, and you know what I don't want? I don't want you to continue asking improper questions. This is not a deposition. You don't get to control the courtroom. Earlier in trial, one of the defense attorney, and it might have been Sykes, said, "You don't have a black robe. This is not Judge
Now, while
Owens."
we talk about this,
Oh, they're excusing the jury to argue. Oh, goody. Oh, goody. Oh, boy. It's the hypocrisy. Your Honor, this is a speaking objection. He does speaking objections, speaking responses, and then talks over the judge. So just for a refresher, a speaking objection is when you start arguing what the objection is instead of saying objection,
okay,
hearsay.
I understand your issue that you think it's collateral impeachment and that it's beyond the scope of
We'll talk about collateral
cross.
impeachment
I'm
in a
going to
moment.
overrule the objections, but ask that there not be a lot of repetition. I think that the door was
Owen.
opened when this witness was asked about the before and the after from
Okay.
family. So,
I'm trying to recall my last question too, that was,
Have it right
the
back.
objection was sustained, or it was rejected.
That would
And
be
then- But there was
overruled.
continuing talk, and I never even got to ask it.
well, you'll have a few minutes to reorient yourself.
Ask the
Dr.
court
Hish, you
reporter.
can certainly step down during the break.
Thank you.
And I get why Owens is like, I've lost where I was. He is sick.
He's asking about what happened with his leaving his hometown. that he'd never let that in. And it's a
Counsel-
collateral issue which I'm going to have to go into.
Counsel,
Consume time and waste.
the judge ruled.
Years before, even if it's true.
I thought there was testimony of both parties. Well, I thought there was testimony of issues with his, when he left his business, that there were issues.
I don't think so. And so,
Your Honor,
and so, just let me finish.
there was some testimony.
So, I mean, we can't bring up Gwyneth Paltrow's.
No, I'm asking you to explain where, well, first of all, where did that come in?
Sure. It's in Terry's deposition, by the way. I think he even used the word like his partner had.
And his daughter talked about it.
If
It's-
it's in his
Cheap-shotted him or something.
deposition, then it's
interesting.
not in the record.
The judge ruled, and
Only
they kept
'cause I
arguing, and
haven't
now
been
we're
able to
back open
finish
an
with
argument
Terry.
again.
But his own daughter, for instance, said that he left, he enjoyed a good reputation until his affair in that community. That was in the record. That's in our, that's in evidence.
Was that in the record?
That's in evidence.
I think you sustained an objection to that, didn't you?
No.
I think you did.
No, it's in evidence because you were making him out to be just this beautifully respected man in the community, and his
That was
own
about
daughter
the
said,
affair, though.
not so.
No, but that was about the affair,
Well, I
though.
think,
Fair is one thing, but I mean.
That was different.
Business partner problem.
I don't think that's come up, Judge. I'm saying it's wrong.
I know I've read it,
Who's
I just don't know if
laughing?
it came out on the record. I don't think it
You're
did.
on the record.
So I know it
Why
to be
is the
true
expert
because
talking to
Mr.
You're on the
Sanderson
record.
So,
actually,
This courtroom
so
is
I asked him,
loose.
we're not proving truth necessarily right now. We're proving, did you see it in the
Right.
record? Because
Right.
they can testify as to what they've reviewed. And then I can follow up on it. So
I
it doesn't
think-
have to be in as a fact,
I think under 403, I'll exclude it. That question,
Which one again? You're on
About the-
business
yeah,
dispute.
business dispute.
Okay.
Because that was about
And,
the affair.
you know, like a certain amount of cross-examination with this witness, you know, and the closer it is to what the daughters observed or didn't observe, the closer it's tethered to that, the more relevant it is to responding to the cross that came out. But if you're, you know, to pull out, I guess, the defense's laundry list of complaints about the plaintiff, or not complaints, but points, I don't know that this is the appropriate place to do that,
That's
given the
very
scope
fair.
of direct.
All the family members are saying he had dramatic changes before, and
Right.
I've been saying, actually, they're pretty distant, and
Sure.
so I'll,
So questions that are tethered to those issues are fine.
Right.
okay, and just so we know what we're doing as soon as we go on, we're gonna present VA record 922 to 924.
And then what, so that's defense exhibits what?
I promise I will break this down when they're done.
Are you introducing these, or are you just showing them?
They're jumping around, so it's hard to follow. So I'm actually like trying to follow what the judge is ruling in this. Because the judge had ruled, and then they kept talking, and now they're doing something else. So I am trying to follow.
And
But the
just
defense
for
attorney
the
reopened the
future,
door. It wasn't, this wasn't Owens.
I'd like to reiterate that when you have an objection, all I need is objection and the rule.
Grounds.
What rule? And if I need more information, I'll ask for it.
Grounds. We just need the grounds. We don't need the argument in front of the jury.
Sure.
Grounds. Grounds.
Usually
Objection.
take about 10 minutes for these breaks.
Objection, hearsay. Objection, compound. Objection, outside the scope. Objection, misstates testimony. Grounds, not objection, Your Honor. This is an unfair question because, and then all of an explanation. I don't know what's happening. All right, it looks like we're on a maybe 10-minute break because the judge said that that they usually take 10 minutes. But then again, we also had a lot of argument right before that. So I don't know how long they will be breaking for. I will be back when they are back. Let's take a minute and talk about what they were just arguing about and then go from there. Also, we are at over 30,000 people. So if you want to go ahead and share that this is where you are you are watching the stream, go right ahead because it's always fun to have more law nerds in the chat, and it bumps us up above all of the other networks. So thank you so much. I appreciate it. All right. Law nerds, for those of you that are new here, welcome. Go ahead and do the like and subscribe YouTube things. It actually helps the channel. Do you know that liking actually helps more than commenting in the algorithm right now? It constantly changes. If you want to stay in the loop, when I am streaming, when I am not streaming, the podcast, the merch, when I'm appearing on different other people's platforms, all the OPP, lawnerdalert.com will get you there, and I can let you know when and where I will be and all of the things. So that is where you need to go, lawnerdalert.com. Y'all broke the website like 4 times. I appreciate you. Law nerds are the best. When we tell law nerds or we tell providers, you don't understand, our community is a engaged community. They're like, yeah, we got it. And then we do something and it breaks. And they're like, we didn't expect that kind of traffic. I'm like, I told you. All right, let's just talk real quick. But first,
This courtroom's a little surreal for me.
the judge has been very patient, but there are times like today when I get frustrated watching it, because as an attorney, this courtroom will be very hard for me to operate in. The judge made a ruling, and then the plaintiff's attorney kept talking, and then the judge kept talking, and then plaintiff's counsel walked away, and then Owens, this is not his fault, was like, wait, are we still doing this? And was trying to figure out where the court had gone. And I felt so badly at that point for Owens, because I would be the exact same way. Like, wait, you just ruled. Why are we still doing this? I would have been just as confused as he was. It's wild to me. Because normally you will have somebody raise the issue and then the other side argue, and then the court make a ruling, and then you either move on to another issue or you just stop. But it's just, they just keep talking and then the court re-entertains it. It's hard for me to follow. I'm sure it's hard for the attorneys to follow. When Owens gets frustrated with it, I can understand why. And he actually did a pretty good job yesterday in the jury instruction argument, saying, Your Honor, can we just do this one and not do that one? And I appreciated it. It's like, can we do this in a linear fashion? So they were arguing over collateral impeachment. It's come up a couple times in this trial. Arguing over collateral impeachment was arguing that what they are trying to use is not the point of the impeachment. When you impeach a witness, it's like, oh, you're saying this at trial, but in your deposition, you said this. We saw a lot of that in Depp v. Heard. Just think about every time Rottenborn or Camille Vasquez was flipping through a binder saying, yes, but previously you said this. That's impeachment. You say this now, you said this before. It's kind of like fighting with your kids and or spouse when it's like, but you said you would feed the cats and they're clearly not fed. And then they're like, no, but I fed the cats. It's like, no, they're not fed. You're not. Bad example, maybe. My kid didn't feed the cats this morning. It's on my brain. Collateral impeachment is taking something outside of the issue at hand and trying to impeach on it. You can't just impeach a witness or impeach a party on everything they've ever done forever and ever. Let's get to some questions because it looks like we've got about a 10-minute break. Which is odd to me because they're going to be breaking for lunch in about a half an hour. This court does give the jury like 2 breaks in the morning, 2 breaks in the afternoon, which is interesting to me. So let us keep going. So let me get to questions. Miguelina, if you could just look at the time of the premiere, it shifted to a different day. Hold on. Court looks like they are coming back onto the record.
Thoughts to yourself, keep your reactions, your emotions, even your facial expressions.
What's the audience doing? Hold on. The judge is mad at the audience. Interesting. Let's see.
Record any arguments of the lawyers, anything that's going on. I would hate to have to ask, someone to leave. So if you could please keep your thoughts to yourself, keep your reactions or emotions, even your facial expressions, until court's not in session. So thank you. We're ready.
All right, that's very appropriate. The audience making big visible reactions in front of the jury is inappropriate. In every single trial we've seen streamed, we have seen the court admonish the audience about it. It happens. Audiences don't always know what the protocol is in court. Lawyers should. Audiences don't always. And so with that, we see the judge again saying you have to keep those visible reactions
Continue.
to yourself. I'm going to see if we can get the stream where I like
Another court hearing at noon.
the audio better,
Your
but
Honor,
they're not live yet,
I'm
which is real
circulating
frustrating
defense
to me.
Exhibit 114.
Why aren't they live yet?
You may.
And then I'll get to questions. Let me see real quick. Counsel, you had 10 minutes. Well, you didn't. That was a short break. But
If I hand it to the witness, we may get you a copy. 114,
Okay.
D114.
Did you
Battleship.
say D as in dog?
D as in David.
Defendant, yes.
Okay. And does the plaintiff have any objection to this witness or this exhibit? Defendant's Exhibit 114D is received.
We're trying to blank out.
They're trying to redact something on the fly.
Examine the witness without displaying it.
Closing arguments are tomorrow.
So, James, page 2 and 3 does not have.
The parties are allowed.
Just blanked out.
The parties are allowed to kind of be the parties. The jury is going to judge the
Okay.
parties, but the audience can sway the
Have you
jury,
seen this
and it's a
document?
problem.
I can't remember.
The
This is
judge
part of
has
his
another
VA
hearing at
records,
noon his time, a half an hour.
It's dated May 22,
I don't think so.
2017. Bottom right is
So the
marked
jury is not
VA
supposed to react
922.
to things, or the audience is not
So
supposed to
if
react to
the
things.
incident was in February 2016. This is about a year.
They
and
have,
3
both
months
sides have
later.
not redacted
You with
well.
me?
Yes.
And if we go to the second page, VA 923, and James is going to bring this up.
Are we behind at all? Can we make you faster?
Under the subjective, and James, I think the address is there, so you want to get rid of it? I'll show you.
I'm glad they're being mindful of it now. It's been an ongoing
Yes.
issue in this trial.
Okay, that's the first paragraph, and where's our cool laser?
Where's our cool laser?
This is a big sentence.
All right, I'm gonna
But I'm
switch
gonna
feeds
start
real
right
quick
here.
to get to the
Patient
cool
reportedly-
laser just because of
And I'll read this.
audio.
Patient reportedly sought out neuropsychological testing for these symptoms, but also feared he may be experiencing early dementia
Oh, no, it's
symptoms-
behind us.
symptoms.
So we're
Mr.
gonna stay here for a
Sanderson
minute.
noted that he felt reassured following the testing,
'Cause it's
but
behind.
is still concerned regarding some of the cognitive changes he has experienced. So that's another reference to him being concerned with dementia. True?
True.
That's all on that. You can take that down, James.
Thanks, James.
Executive function testing, does that rely on the patient, some subjective reports from the patient?
I believe so, but I'll have to defer to our neuropsychology experts later today.
Okay, they're gonna come up here and talk about that, so we'll be okay with that. Patients can throw neuro testing though, can't they? Can
Yes.
they, like, fill in the tic-tac-toe, and the patient can actually say, I don't know.
Overruled?
Yes.
I mean, we can't force him to put a
They
zero
have,
where it belongs and an X
they
where
have
it belongs.
malingering
Fair?
controls.
And are you aware of
I
a
can't
studies
with the
that say
audio.
being a litigant in a case like this actually frequently leads to patients overstating their damages?
Objection, 401, 403, and beyond scope.
Overruled?
Go ahead.
Yes.
Just comment on what you know on that.
So I would say it's more just knowing from medical school and learning about, what malingering
Malingering.
is, as opposed to studies that you you state.
I'm going to switch real
Okay,
quick because
malingering is a word that means basically not trying as hard. Is that
not
fair?
that's
For
not
secondary
exactly.
Malinger.
So we're gonna be
I have a-
we're gonna jump back just a moment to pick up another feed that's a little bit easier for me, audio wise. So thank you all for your patience. It's frustrating because a lot of the feeds don't come back at the same time.
Experience. So that's another reference to him being concerned with dementia. True?
True.
And it's not overgained,
That's
so we don't
all
get the
on
same
that.
white noise,
You can take that
which
down.
I very much appreciate.
Subjective reports from the patient.
I feel like I'm over explaining.
I
Apologies.
believe so, but I'll have to defer to our neuropsychology experts later
Yeah, I
today.
think it's
Okay,
the
they're gonna
wrong
come up
the
here
wrong
and talk
definition of
about that, so
malingering.
we'll be okay with that. Patients can throw neuro testing. though,
Malingering is
can't they?
appropriate in this
Yes.
context
Like,
because it's a,
Fill in
a
the tic-tac-toe.
appropriate term
And the
here.
patient can actually say, I don't know.
Data, I'm working on it.
Overruled?
Yes.
I mean, we can't force him to put a 0 where it belongs and an X where it belongs. Fair?
Correct.
And are you aware of
KJ,
studies that
yes.
say being a litigant in
Green
a case
screen
like
head
this
will be recalled. This is not that
actually,
witness.
frequently
He's a different
leads
dog.
to
But that witness will
um,
be recalled tomorrow morning.
patients
We're told.
overstating their
The
damages.
whole afternoon will be experts.
401, 403, and beyond.
The whole afternoon will be experts.
Overruled?
Go ahead.
Yes.
Just comment on what you know on that.
So I would say it's more just knowing from medical school and learning about, what malingering is, as opposed to studies that you state.
Okay, malingering is a word that means basically not trying as hard. Is that fair?
We are now caught up
Correct,
to where
for
we were when we
secondary
switched
gain.
over.
And malinger. If I have a stubborn cough that's malingering, is that the right
That's
use
so
of that word?
rude.
No, it would be if you were elaborating your symptoms, like you said, not filling in the tic-tac-toe
Trying
in order
to
to
throw it
have
on the
some
other
type of
attorney.
secondary gain.
All right.
That's Owens. I mean, he didn't point a weapon at counsel, I suppose.
What we do
he
know
just
is that he ran a business in Idaho many
shame.
years earlier. True?
Objection, Your Honor, same thing we talked about previously.
Overruled?
True.
And then he retired in part due to his failing eyesight. Do you know that?
I don't know that.
All right. And do you know anything about losing the respect of his community, which his daughter reported to this jury?
Objection, leading.
Overruled?
Sounds familiar, but I don't know the details on that.
Due to an affair he had.
Your Honor,
that's leading.
401, 403.
Sustained?
Thank you.
Owens
it's
is like
in evidence, and I think he should
land
be
the
able to
plane.
Reference it.
Same objection.
But
I think there's also no
respect
foundation.
Your ruling.
You have no choice. The judge is very patient with these attorneys.
Can anxiety and depression and hyperfixation, can they throw off executive functioning?
Yes.
Or can they
All right.
be a symptom?
One thing Sam Goldstein said the other day was that he's
Oh, that
he's
sounds much better.
obsessed. He's obsessed with this case, this notoriety, this media. Can that throw off if someone's obsessed, can that throw off their executive functioning?
Yes.
Objection, foundation.
Overruled?
Just comment on that for me, please.
Yeah, so being obsessed, being extremely anxious, or having other, being depressed, kind of that's a whole continuum, can cause a whole host of cognitive dysfunction, including executive function, but also problems with concentration, attention, memory, all the above.
I'm being told to sit down. I'm sitting down. Thank you.
It's so odd to me that he says it.
Mr. Sykes?
It's just odd to me that he says I'm being told to sit down. like you're letting the jury know that you've been told you've been cut off. Every single time he does it, it confuses me. Every time. I will never not be confused by that. It's just, okay, Mr. Sykes. They got what they needed out of this witness, and they're going to run out of time.
Doctor, in that report that you have there,
I wonder what everyone in the gallery is looking
progress
at.
note from the VA,
They've got to be very
May 22,
mindful of time.
2017. I'm just looking at it, Exhibit 114.
Yes, sir.
Oh, I definitely think it's because of time at this point.
This was a.
This is a good witness, but they've got to get to the
read
neuropsychologist.
the reason for the visit.
Would you like me to read it? Oh,
Yeah.
scheduled psychotherapy intake.
Okay. And the chief complaint, anxiety, adjustment to medical condition. See that?
Nicole,
Yes.
I'm always open to people having a
And then
different
on
opinion than me.
Page 2, some of the things that weren't read. Let me see if I can get those up there. Let's see.
I really hope we get to Jenny's depot too. I'll be really bummed if we don't. Honestly, real bummed. Paltrow's
subjective.
insurance
Now,
might have
Mr.
picked
Owens-
these attorneys.
Read you part of that. Okay.
Cross. The
can you
attorney
see what I'm
talking is the
referring to
one. The
here?
time is.
Yes.
Okay, he says,
Feared.
recently referred by Dr. Manson following neuropsych testing, where anxiety was suspected to be affecting patients' cognitive functioning. Do you see that?
Yes.
Yeah. And Mr. Sanderson reported that he was in a ski accident 1.5 years ago, where he was hit by another skier who lost control. He reportedly had 5-minute LOC and
5-minute loss
broke
of
4 ribs.
consciousness.
See that?
Yes.
And he was evaluated and told he had a concussion.
I don't think it was 5-minute loss of consciousness.
Yes.
I sure don't.
And that's actually what happened. He was evaluated and told he had a concussion, wasn't he?
Yeah, that's what we
By
discussed.
several.
Yeah.
He said that over the past year and a half, his cognition has gradually improved, right?
Correct.
Now, people that are malingering don't go tell their doctors that they've improved.
Yes,
do
it
they? Do
does.
they?
I don't know that I can make that general statement, but I think the fact that he improved, we talked about, which is a sign of.
But he has continued to have
concussion.
difficulties.
Your Honor,
With-
Bob interrupted my client.
I'm
Or-
sorry, I didn't mean-
Sorry, my expert.
I'm
Can
sorry,
you
I'm
finish
sorry.
his
But you-
answer?
I didn't mean to interrupt you.
Allow him
finish
to
your
finish.
response?
Well, I was just saying that we did
Allow
talk
him to
about this
finish.
earlier, that he had gotten better from the concussion.
Not gotten completely better, but he improved, right?
He improved. That's
Says his cognition has gradually improved, but he's continued to have difficulties with motivation, energy, and
Yeah, the
anhedonia.
5 minutes LOC, I don't believe,
That's a term that the jury may not understand.
and it doesn't match the evidence.
Loss of enjoyment of life.
correct.
Okay. So, at least 2 of the 3 of those are things you commonly see with executive functioning problems, aren't they? Motivation, energy.
Correct.
Okay.
This trial's stealing my motivation.
He also described difficulties with spatial tasks such as driving, getting lost, and puzzles. Those are frequently executive functioning problems, aren't they?
Yeah. There are also major signs of dementia.
Okay? He reportedly sought out neuropsychological testing for these symptoms, but also feared that he may be experiencing early dementia symptoms. Okay?
I think it was smart for him
Yeah.
to think that.
Smart. Mr. Sanderson noted that he felt reassured following the testing, but is still concerned regarding some of the cognitive changes he has experienced, right?
Correct.
And you understand that he was tested and told he doesn't have dementia. You understand that?
Yes.
And no diagnosis of
Correct.
dementia, ever. Right?
Correct.
Okay. Now,
I think that's important for them to get after on cross.
also,
Because I know, at least in the chat, people have been
A
asking, aren't these
patient,
things consistent with that? And given his age,
sometimes
it's going to be a
neuropsychologists call them
question.
clients, but you call them patients, right?
Correct.
Okay. Patient or a client who has high scores in some areas is not generally a person who's trying to fake it, right?
Correct.
High scores, right?
Correct.
You
And in
would
some
see
areas,
it across the board.
some intellectual areas, Terry Sanderson has super high scores on testing, super high. Right?
That's going to the
That's right.
malingering factors.
Hold on one second, Your Honor. I think I've done it here.
Okay. I don't know if the court's gonna try to get 15 minutes of another witness because they are running low on court time
No further questions.
and they've got about 15 more minutes.
Mr. Owens?
No, Your Honor, no more questions, thank you.
All right.
Thank you,
Dr. Hesh. You're
everyone.
excused.
Thank you.
Thank
Good
you for
work,
coming.
everybody.
Thank you.
I think we've got one more witness before we get to lunch.
Just leave it right there in front. Thanks.
Oh, you know what? I do have one more. You mind if I just take one more minute?
Oh, gosh.
I think he's excused.
He's excused.
Sorry, Mr. Sykes.
Yeah, he's still in the courtroom.
Do you have another minute?
When do they finish
All right, come on
Sanderson's
in.
Cross? They said they aren't going to.
You're still under oath?
Owens said last night he's not going to.
I apologize for missing this one. You talked a little bit about NPH,
Yes.
normal pressure hydrocephaly or
Outside the
hydrocephalus.
scope
That's
of
correct. That is a
direct.
condition, is it not, that can exist for years and years and years without any symptoms.
Correct.
And the three main symptoms of NPH, if it's active, okay, are ataxia, dementia, and loss of continence.
Correct.
Okay. And
Ataxia being problems walking.
problem walking. And there's no diagnosis anywhere in those records before you that anybody ever diagnosed him with NPH.
That's right.
Okay. And a lot of good doctors looked at him, right?
Correct.
Thank you.
Mr. Owens?
Oh, God.
Entirely separate from the ski accident, do you believe Mr. Sanderson would benefit from anti-dementia medications?
Your Honor, I object. That's beyond the scope. I asked only about NPH.
That was Your Honor, he
Overruled?
go ahead.
I think it's worth a trial. Low side effects, and it could help him.
And Sam Goldstein felt the same way.
Correct.
That's all, thank you.
Mr. Sykes, anything further?
Owens having the finger up
Okay.
at counsel is
Thank
funny
you.
to me.
Should now run from the courtroom.
That was funny. I will give you that one, Owens. That one was funny. You should now run from the courtroom. Was funny.
Mr. Owens, you may call your next witness.
Thank you. James has this one. I'm giving the clerk the official 114.
Generally,
we call Dr. Angela Eastvold.
generally that wouldn't fly. This judge has been patient and pretty permissive. Generally, once a witness is excused, it's too bad, counsel. The judge allowed it because he was
Do you swear
standing
that the testimony
right
you are
there.
about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, they've got about 15
you.
minutes.
Good morning. Would you take a seat and then state your name and spell it?
Oh, you don't know. Okay. My name is Angela Eastvold, Angela Eastvold.
Eastvold. Okay.
Thanks for being here, Dr. Eastvold. And I believe, Your Honor, you said you have a hearing at noon, and so we'll be quick for the first part here. Would you like to end right at noon or a little bit before?
Maybe a couple minutes before would be great.
Okay, great.
One or
James
two.
is like,
Sure.
I've got my
I'll
eye on
keep
the
my eye on the
clock.
clock. Dr. Eastvold, what do you understand your role to be in this case?
I was hired to review the records and
Friday
provide
catch-up,
opinions
correct.
on the facts around his injury.
Experts are allowed to hear
Okay,
other
and
testimony.
Were you asked to look at Dr. Goldstein, plaintiff's neuropsychology expert, and his evaluation in particular?
This is an
Yes.
expert, so
But
I
you
would
looked at everything. You looked at all the records.
I did.
Rob, they're
And
going to run
we
out
don't
of
have to
time.
Name them all. There are thousands, correct?
Yes.
They're going to
And
run out of time.
they span what period do you recall?
2004 to 2022.
Okay.
May,
And,
thank you for sharing that.
I think
I love it.
after we come back from the break, we'll do what we did with Dr. Hesh. You have a report that also has some headings, and that will help us take you through those. But if we may start with just a general understanding of your expertise and why the jury should listen to you about these matters.
So I'm a board-certified neuropsychologist. I have a PhD in clinical psychology with a specialization in neuropsychology. I then completed a 2-year fellowship at the Veterans Hospital in Tampa, Florida, where I received 2 years of specialized training in the full spectrum of brain injury, from mild to severe. And brain injury has been my primary area of expertise since. I was then a faculty in the neurology department at the University of Utah for 6 years, and during that time, I regularly lectured to physicians and psychologists and trainees on concussions and provided continuing education courses on concussion diagnosis and management of this. And then since 2011, I've also been an independent consultant to professional sports teams as part of their concussion protocol. That is all required now. So when a player gets a concussion, they are required to have an evaluation by me in order to be cleared to return to play. So I am
Judge H's
deeply
cup is full of
involved
patience.
in concussion. And for the past 2 years, my work is 80% concussion.
Paige, they're done with all of the
So
fact
in your
witnesses
review
of
of
who
Mr.
caused the
Sanderson's
accident.
medical
We're not going
history
to hear any more about
and
it.
other records, I guess we should mention, did you review the Deer Valley records?
I did.
Okay, the incident report and the instructor comments, these accident records, you reviewed those?
Yes,
And you reviewed
Yeah, Janice,
depositions
this is going to
connected
minimizing
to
the
events
monetary
of the
damages.
collision.
I did.
So in your review of all of that, what is your opinion about Mr. Sanderson as it relates to concussion?
You want me to go into my first opinion?
Yeah, we'll get to it, but just for the
Okay.
general review.
In
yeah.
general, that if he
Overview.
suffered a concussion, it was at most a mild concussion.
Great. And what about the symptoms connected to that concussion if he had one?
I believe that the symptoms resolved, or the symptoms that were there might be better explained by other conditions.
That pre-existed the collision?
Yes.
Hannah, each team gets an hour unless
Okay,
they
so
have more
that's a
time
good, just
left.
general overview. Anything else you'd add
But
as
the
a
court
general
only
overview of
has
your opinions?
about 2.25 hours set aside tomorrow. So the court said
No.
they could start their
That's a
closing
good, just
earlier if
short,
they're
again,
done
we'll-
earlier.
we'll get into
Introduction, yes, there's a lot of details I'm looking forward to going into.
Okay, great. So
This is the
I wanna pull up the
neuropsychologist.
exhibit that
So neuropsych,
jury was just looking at with Dr. Hash. It's plaintiff's
who specializes
exhibit
in
P43.
brain injuries.
I just switched my iPad here into the system. It looks like it's taken a second.
As they do. I'm going to answer questions while James is taking a minute to get the tech
This is
to work.
the executive functioning
Was it
table.
Gwyneth who told him to sit down?
Do you
I don't know if it
recall
was
seeing
Gwyneth
that?
or
I do.
James.
And do you recall reviewing that in
And we'll talk about character a little bit later.
Dr. Goldstein's evaluation of Mr. Sanderson?
I do,
And that's where this comes from.
correct.
And
That's funny.
I'm going to just pull it up right here and ask you,
I like
what
whatever
does,
program they're using on the
this
iPad. It's
table,
really
what
a
is
nice,
it trying to accomplish?
Okay, this
a
is
nice
important.
animation.
So this is a self-report measure that Dr. Goldstein himself designed and published. I can't speak to it. It's not something that is commonly administered in clinical practice for adults. I've never seen it used anywhere other than Dr. Goldstein. So I can't speak about the validity of these scales. But what I can
Because
say
she
is
doesn't
that
know the
this is a
scales.
really nice quantification of the patient's subjective complaints. It is not evidence of objective deficits. It's just a summary and quantification of what the patient is reporting.
Well, good to know the scales. I
And
feel like
so
we
if
learned
you-
a lot about
if you
that
would
in
for the
Depth
jury,
Heard.
when you use
as
those
an
terms
audience.
subjective and objective in a neuropsychological sense, what do you mean by them?
So subjective is just the patient's opinion or
This is the first
perception.
person who's explained these
Objective is
scales. I
something
find
that
that
is
very helpful.
measurable. And when we get into the neuropsychological test results, those numbers are objective data. And I will later show you how some of these contradict some of the objective data.
I'm wondering why they have two
So
neuropsychs.
is it your opinion that the results here that plaintiff's attorneys have been going through, those represent only Mr. Sanderson's report of
Mr. Sanderson.
his own sense of his executive functioning?
Exactly.
And there's other evaluating physicians or neuropsychologists that have done objective evaluations, is that correct?
Correct.
And can you give
Oh,
us
they're
a
gonna be
just
wrapping up
brief
in
sense
just
of
a few
what those
minutes.
are, when they happened?
And I
So
will
he
be
had
too.
a battery of tests that measure multiple areas of attention 1 month post-injury. He had a battery of tests that measures multiple aspects of memory 2 months post-injury. And then he had a full neuropsychological evaluation 1 year post-injury.
And what did those exams
And then he had
show?
Dr. Goldstein's evaluation, which is 4 years post-injury.
Right, thank you. So in all of those evaluations, what would you say as a summary of the findings? You can
No.
take them one by one if that's best.
Your Honor, I object. There's nothing in her report about this.
Huh.
It is in my report, and
Yeah,
I would love to be able to talk about it in the context of my first, of my
So you have to
opinions.
listen to the
I'll have to
judge.
deal with the objection. That's okay. That's quite all right.
This is
I
not
will
a
do that.
deposition,
Maybe
ma'am.
we could do that over lunch.
Sure.
And do you have another area that you want to go into for the next 5 minutes?
Seems like this is a good time to wrap up if.
Okay. Why don't we take our recess now, and then we'll return at 1:25.
Okay, thank you.
Thank you.
Okay. So they will be back from lunch in a little bit. They are going to lunch now. The judge is excusing the jury. I'm not going to leave yet because inevitably when the judge does, he has a hearing in 5 minutes. He's probably going to put the objection on the record. But again, this witness, the plaintiff's attorney was like, objection, it's not in the report. And then the witness started responding back as opposed to waiting for the judge to respond back, which was very interesting. So
Not a deposition, is that right?
No deposition. It was just,
Okay. Let me pull that up, and then I can address your objection.
we're gonna stay here while they address the objection.
And if we can, Your Honor, we know we're on the clock, and we're in the sort of the last
The
5 hours or
final
so of evidence.
countdown.
If we can get an update, we would like one.
Okay, yeah, we can do that over the noon hour.
You
All
see the
right, so,
clock playing a
remind me
huge
again, what was your
factor.
question, Mr. Egan?
I was just asking about the post-accident evaluations, and she does discuss those, I believe, under section 3 of her report. And maybe
Egan is not at the
also
mic, which makes it very hard to hear.
cognitive assessments in March and April of 2016. She talks about those there. And then she talks about Goldstein's and the 2017 Dr. Madsen evaluation in point 3.
Okay. And so that was the direction that you were going based on using the parameters of her reporting?
Yeah.
all she
Okay.
talks about is March and April of 2016, March 8th of 2016.
This is under 3, neuropsychological evaluation.
James is like, it's there.
Madsen, 2017, and then she talks about Goldstein's evaluation.
James is like, I've got my binder and my highlighter.
Okay.
It's different than what.
So the subject matter in general is certainly within the scope of her report, so objection will be overruled?
Your Honor?
As I've said, it's under point 3, and if you go a couple paragraphs in, you'll see it.
James is like, as you can see in my binder, it's right here. It looks like James has one binder per witness.
All right, so objections
Which is something
overruled
I
on
like
that
doing.
question, and if you need the court, this pretrial should take no more than 45 minutes, so you can let the clerk know and we could get back together if necessary, but otherwise, 1:25.
Should we clear off the tables?
No, I'll go to the next courtroom.
Just update, we intend to ask our 2 neuropsych
Yeah,
people.
the other attorneys don't want to be in this courtroom.
Terry Sanderson to the
It's
stand. Can
termed.
we confirm?
Your Honor,
He will be in the courtroom this afternoon.
Your Honor, they released Terry Sanderson. They said they weren't going to call him again.
Yesterday.
Yeah, yesterday.
So were you
But that
there?
that was for the, to complete their
Ew.
cross of the scope
Yes,
of your
they
direct.
said they were gonna
They're
recall
gonna call
him.
him under the rules as the adverse witness in their own case, so. Anything else, counsel?
No, I just want to make sure he's in the courtroom this afternoon.
In the courtroom or available to testify?
Oh, I thought he was going skiing. Sorry.
Okay. Can you make him
He's
available,
trying to-
Mr. Sykes,
he's
this
trying to make
afternoon?
a
No
joke.
problem, right? Okay, thank you.
What I said Utu was Owens saying to counsel, were you there? These counsels were sitting there when this happened. I watched it yesterday. The were you there is just
The
so
plaintiff
odd.
has used 42 minutes, and the defendant has used 1 hour and 35 minutes. 42 minutes for the plaintiff, 1 hour and 35 minutes for the defendant.
So that's what's
Thank
been
you.
used today so far.
If I have time.
And the judge is walking off the bench to go to his next hearing. We are breaking for lunch. They are going to have the rest of the neuropsychs this afternoon, possibly Terry Sanderson being recalled. They want to read in the deposition of Jenny. I don't know if they're going to get to that. I think it'll be very disappointing if they don't. I'm going to answer some questions. Court is on break for the afternoon. I've got the Emily Show podcast premiering during that break, but I've got some interviews that I need to get to. And then I have things this afternoon. So I will summarize this afternoon tomorrow morning before I start. I will not be here this afternoon. So let me, so chat, thank you. Try not to distract with that. I want to try to get to answering your questions real quick, and I'm going to do that. So Emily, I found your crackers for my hubby to try was grocery stuff this morning. My husband has been very helpful with grocery shopping because I've not been able to get it done. So a few housekeeping matters. First, if you want to stay in the loop while when I'm streaming, where I'm streaming, and what else I am doing, lawnerdalert.com will get you there. If you have not done the YouTubey things, the liking of the video, the subscribing, go ahead and do those. I would appreciate it. I'm going to answer some questions, and then I have got to scoot to things I had pre-planned this afternoon. So with that, let's get to questions. I meant to do this earlier, and then the court came back, not 10 minutes. As I rearrange my screen so I can see just a little bit better, because it's a lot of chat. It's good to see everybody today. This trial, man, I know a couple people have asked for me to do a poll on who I think will win. I generally don't do those types of polls. I still think this jury could very easily come back with a 50-50 verdict being y'all skied, you're both there. I will ask at the end whose closing argument you find to be more persuasive at the end. I like polling on whether the lawyers have been helpful and things like that, whether the witnesses have been helpful and things like that. So let's see what else. I'm going to get to some questions. We're going to speed run some, and then I have to scoot. Morgan said, is this because Ramon likes to tell great dinner party stories? I have no doubt that T got a TBI and makes sense for him to want to believe Ramon's story and have someone to blame for those life changes. And I wonder what the jury will think about that. Marjorie said, I have been thinking of the doctor commenting about PCS being a money litigation media grab. What if those are symptoms of PTSD? I was off put by that part of the testimony. It also, the judge immediately came in and was like, absolutely not, and struck it from the record. But that doctor was a good witness. And I was really confused that doctor was going, oh, if post, concussion symptoms last more than 3 months, it's a money grab. I found it very off-putting, and I wonder if the jury will too, because he was otherwise, up until that point, I was like, oh, this makes sense. And then at that point, I was like, sir, what? Yeah, I found it very off-putting. And the defense should know that. Beats Kill Bean said, question, what does it say about me that Owens makes me miss Elaine? I'm questioning everything about myself. Look, we all have styles that we prefer and styles that we find off-putting. James is a much more linear attorney. I find it much easier to watch, personally. It is much clearer. It's much easier to follow. The job of an attorney on direct examination is to make sure the witness testimony shines, to make sure that the jury understands exactly what that witness is trying to say. Your job is to facilitate the story and get out of the way. On cross-examination, your job is to tell the story and then have the witness say yes or no. On cross, it is sometimes to impeach the witness, to show that that witness is unreliable. Sometimes it's to use that witness for your advantage. But the lawyer is kind of the star in the cross-examination. You want the jury focused more on you most of the cross-examination. During direct, you really want the focus on getting that story out clearly. I prefer simple questions and more of them instead of one big question that has 9 different parts to it. if you go back and look at the direct of Johnny Depp in particular, you will see that the lawyer asked a few questions and kind of got out of the way so that he could testify. And we've seen that with James, with the doctors as well. He asks a question and then really kind of gets out of the way so that the doctors can answer, and then follows up with those questions. So that's really very helpful. Owen's sense of humor is exactly like my son, ADHD and high functioning autistic. Due to this, I find it awkwardly endearing. And that's very fair. It's very fair. I think in a deposition, I wouldn't be so off put by that. I wouldn't be as I don't know, I think as critical of it. But in trial, some of it is just, this whole trial has been a little like, it's odd to me, and I find it somewhat off-putting. Sometimes in trial there are moments that are unintentionally funny and unintentionally light. It feels like people are pushing it, and it feels very much like depositions to me. And that, I find trial to be a more solemn event. You're taking people, and maybe this jury likes it, but you're taking people out of their work for 8 days to talk about a ski collision, and then you're just like, so you're a nerd. I can only imagine that the jury's sitting there being like, can we please keep moving? Can we please keep moving? Emily, why don't they bring in a I'm not going to pronounce this well, but a doctor specializing in aging to prove normal aging? I don't know. They could have, but they didn't. Sorry, my in-ears are just all over the place. They could have, but they didn't. They get to choose the doctors. Jamie Blue said, this is surreal for me. I am being deposed for a wrongful death suit for my mother in Utah. IHC is one of the parties in the case. Do I need to stop watching? Oh, I wish I had seen this sooner. I don't think you need to stop watching, because IHC in your case is different than IHC in this case. And this doctor works there, but was not giving an opinion of IHC. And Jamie, just from me personally, and I'm sure from a lot of the law nerds, I'm so sorry you're going through it. Dealing with the passing of a parent is awful and complicated in its own right. Having to then deal with wrongful death makes it a very difficult circumstance. So my heart is with you as you walk through it. Stay strong. Have someone to vent to. Get support for yourself. Going through that is very, very difficult. Give yourself grace for how difficult it is. Clearly the plaintiff had conditions before and their trajectory didn't change, but did the impact accelerate trajectory? That needs to be discussed. And I think it does. I don't know if it will be. I thought it was helpful for the defense doctor to say, if you look at the medical records before accident, after accident, and take out the accident, they still make sense. That's a very important bit of testimony. We'll see what happens afterwards. Leslie Ann, are Patreon memberships and channel memberships two different things? Yes, it's not a dumb question. And I will just say, you don't need to preface ever, sorry, dumb question. There aren't dumb questions ever. This is something that I get particularly triggered by as being an ADHD neurodivergent person. I always felt like I had to couch my questions. So don't apologize, never apologize. You can just ask and we will just go for it. I'm here for all the questions. I have questions and I don't mind being asked questions, because then I know what to answer and I know what I've missed. And I know sometimes where I've been maybe overly critical, or I haven't explained why I'm critical, or I haven't explained why I'm not critical. So asking questions also helps me explain better. Roxana said, is it just me, or has the judge been turning his head toward defense table a lot the past 2 days while questioning witnesses? I want to know what or who he is looking at. I haven't noticed that at all. I haven't. So I wonder, he could be looking at the audience, but also the judge's clerk sits to the side of defense table. So the judge could be looking at the clerk to maintain the courtroom, or to get information from the clerk, because that's where his court staff sits. Again, Colleen, no silly questions. If plaintiff rested, why can they cross? Or is it that they can't call additional witnesses? Sorry, I'm confused. They can't call additional witnesses until the defense rests, so they can still cross. So each case goes plaintiff, defense, rebuttal if need be. And then within those witnesses, unless they're out of order, it goes the calling party. So plaintiff would call a witness, defense would cross-examine and then redirect and then recross, and this court just seems to keep going if the parties want to use their time that way. So they can't call any fresh witnesses for their case in chief. They can call witnesses on rebuttal after the defense rests. Hopefully that explains well. Rihanna, question, can you please re-explain eggshell plaintiff and whether it tends to or is meant to favor the plaintiff or the defendant? It's more of a theory, and how this gets codified in different jurisdictions is different, but you take a person where you find them. So it's not as if, if Terry Sanderson was walking around with things that made him more susceptible to injury after a collision like this, that is on the person who collided with him, if a person collided with him. So if he's more susceptible to injury and those injuries are still caused, that's still damage caused by the other party. It's not, well, an average person wouldn't have been this hurt, or a person without this issue, or a person without being this age wouldn't be harmed this way. It's like, no, you take the plaintiff as you find them, even if they have underlying things that make them more susceptible to injury. Question, why doesn't Owen let the other attorney in his team do the questioning if he is so sick? It seems like both attorneys are sick. I have been in court sick. I know I have been in court with high-risk pregnancies. People, lawyers to the detriment, I think, of our profession push through because it takes so long to get to trial. When you're in trial, you have to go. And with that, you are prepped for the witnesses you're prepped for. Prepping for a witness that you're not prepared for in a case like this can be very, very difficult. So these attorneys are pushing through even if they are sick, and they have already prepped those witnesses. It's very, very difficult to shift. So why is the doctor being used by the plaintiff to bring up all of his witness testimony? I feel like I am listening to his closing. I'm confused. Because he can, on cross-examination, turn that witness into a benefit for him. Question, where is the line for badgering the witness? From a lay perspective, Sykes's aggression seems like it would cross the line. It's not really something that goes to style. It goes to repetitive questioning. And the argumentative part of it is when you're arguing back and forth with a witness. And that was not, though you hear argumentative and you might be like, well, his style made me feel like I was being yelled at. It feels argumentative. It goes not to the tone. Most of the time, it goes to the way the questioning is happening, and there was no objection to it. So he wasn't at the point of being argumentative, and he wasn't at the point of harassing a witness. So that's why. I wrote you I like big boards ditty to cheer you up, but it wouldn't fit. Specifically, how can I get it to you? My email is public, so you can send it. My public email down below and all over the places. Blurred silence. My grandfather died of MPH. People with MPH have difficult time moving about, and lose ability to walk. No way TS had MPH since 2016 and still walks. And that's what the plaintiff is really keyed on, is the continence and the walking is a huge factor. And he was still skiing. So he chose to end it, not her. Masks. I'm not sure what. Oh, that's regarding the relationship. Chad, I see you guys. I will never mention again when I am and am not streaming. I'll just send it in the email. Please don't harass Rob. He will stream if he can and if he wants to, but he also still maintains a practice. So please don't use the chat to ask him. He will share with you if he chooses to. Don't worry. I would like to answer some questions and then get back to it. But if it derails the chat, I just ask to not. I know when I go into other chats and I cannot stream, that I feel very bad when people are like, please do this, please do this, please do this. And I'm like, I can't do it right now. Rob and Runkle both have very busy law practices. So please don't. I'm just trying to answer questions and then get out. They will let you know if they're streaming, and if you follow them, they will let you know that they are streaming all over the internet if they decide, I am sure. So thank you, because I've only got a few minutes left. So thank you all. Not related to this case, but I was wondering, can a judge cry like when a case is sad or upsetting when sentencing someone? Um, when sentencing, judges get to give a bit more of their insight to things, and we have seen that in the Brooks case. You have seen it with the judge in the Brooks case. Judges are human. You generally won't see it when they're on the record, and they will take a break if they need to. Um, but in sentencing, you see a little bit more of their feelings about a case. If you go watch the Brooks sentencing, you will see that people have different opinions on it. I think judges are human. And I think with judges being human, you are going to see their emotions, particularly with difficult cases. The Brooks case was a very difficult case, and the judge being very human in that moment when sentencing, I found to just be very real and very human. So that's part of it. But yes, they can. If that is during testimony in front of the jury, I don't think that would be appropriate. And judges do take breaks if they need to in difficult cases. Lawyers, a lot of the times, will also shut it down. I mean, lawyers are partly trained to put their own emotions aside. When you get overly emotional, when you are the one in trial, it can also cloud your judgment. So there is a parsing of emotion versus work. And building up that wall is part of lawyering so that you can do your job. It's not always easy. It can take a toll on you personally. It is one of the difficult things in the field of law, but it is part of being an attorney, is being able to put, it's not different really, I don't think. And I was an athlete up until college, and through college until I got hurt. There is a part of athletics where you put your emotions aside and you play your sport, you do your thing. Theater, music, when you put your emotions aside and you get into the game and you're in the zone. Lawyering is the same. Being a judge is the same. You put it aside until it's appropriate. And sometimes that takes a greater cost on some than others. Casey Cat said in the end, TS had to prove GP caused the crash to get money. In my opinion, he hasn't done that. I think we might be at a stalemate on who caused the crash still. Caught up at 2 times speed. I appreciate that. Doctors do the same thing, right? So people in jobs all over do this. This is not unique to law that you have to focus on work. People do this all the time, but law can be tremendously gut-wrenching. Emily, I probably missed it, but is Jenny testifying? They might read Jenny's transcript in, and if I miss that, I'm going to be very sad. In the parent pickup line, and they all hear you sing the final countdown. It's early for pickup line. Maybe it's early release. Speaking of which, I've got to go get some food. Joining late and listening 2x speed with EDB's 1.25. That would be very fast. If Terry is found liable for causing the crash, will any of his mental status matter? No. The jury has to find liability first. So liability first and then damages. So if they don't get to liability, if it's 50-50, no one gets damages. If they find that somebody is more at fault, so somebody is like 60% liable, 70% liable, 90% liable, 100% liable, then the other party can get damages. And with all of that, chat, I don't see a lot of questions. I see a lot of other discussions. Question, what happens if a lawyer has a family emergency? Are they allowed to leave during trial? Oftentimes, there is not space for that or timing. This judge has to be done. This court has to be done. We saw a witness in the Murdaugh trial. His mother passed away the day before, and he was on the stand the next day testifying. It is a very difficult thing, but when you are in a trial, trials can cost the state and the taxpayers hundreds of thousands of dollars, and the court has a very limited period of time, and it can be very, very difficult. But oftentimes, no. You have to wait until the end of court, but it also depends if you're in trial, if you're just in hearings. There was a day when I was in court. I mean, I had a lot of great experiences in court. I had some difficult experiences in court. I had some crazy experiences in court. Court is court. It's very dynamic. But there was a day where a friend's mother had passed away as I was on my way into work. This is someone who I grew up with, who felt like a second family member to me, and I was discombobulated. I did not have much to do in court that day. I let the defense attorney know, hey, can we argue this motion later? I am not well composed. I don't think I will be well composed. I am very rattled. And I told the defense attorney what was going on, and they're like, of course, this motion could be argued next week. We're not up against time. This isn't something that we have to just do. And then I went to the judge, and the judge was like, absolutely not. Absolutely not. And it was tremendously difficult. And so it really just depends on the circumstances and whether you're in trial or not. In trial, I would turn off my phone, and there were times it was hard. And I would tell school, look, if something happens, and it did. There was a day I was in trial, and my kid fell at school and needed stitches in his chin. They called my husband at work. We had emergency contacts. You just have to plan to be out of reach when you're in trial. So you could not reach me while I was in trial. But I imagine my sister-in-law is a surgeon. You can't really reach her when she's in surgery either. You have to finish the job, and you have to make accommodations in your life for that. At some point, that no longer worked for me very well. So having a little bit more control over my time is what's needed. But that's your work, right? You choose it. You know when you're going to be in trial, and you know where you're going to be, and you make accommodations for it the best that you can, and you ask for help the best that you can. But work like that needs support, and you have to ask for support. Does the jury have to request testimony to be read back? Like showing the daughter did talk about it. Only if they care. They might not care. It might not matter to them. So only if they want to, but the jury can ask for readback. So, let's see. This stream will link you to the Emily Show podcast for the afternoon. If you want to watch that, it is covering the Murdaugh of it all that we haven't gotten to yet. And then I will see you bright and early tomorrow for closing arguments. If you want to know exactly when I am streaming and where I will be, lawnerdalert.com. Thank you for being here, chat. Thank you for being Law Nerds. Y'all are amazing. I'm sorry to let you loose on the internet. I trust that you will have fun. I will be catching up later tonight on 2 times speed to see what I missed, so I am prepared for the morning, but it's going to take some time for me to do that. So I will see you around the interwebs, and I will see you for closing arguments. Can you believe it? Closing arguments. We're here. We're here. I will see you soon. Bye. You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.